weekly list, old matter, item number 1.
May I be permitted to appear to VC, Your Lordship?
Yes, please.
Yes. Is the manufacturer of boiler chicks, Your Lordship. It's a hatchery company, Your Lordship, and it's challenging the impugned order passed by the board wide annexure 8 at page 115. The facts of the case is that 1992, I had approached the board and with an agreement, a 56.5 kV watt was given to me. Subsequently, and I was coming under the policy, industrial policy 1986. In that policy, there is a category for commercial purpose, and subsidy was given to industrial use. I am coming on though the commercial.
So 1 minute. There has been no interim order here, correct?
No interim order.
So now this is come to your prayer clause.
Yes, sir.
Come to para C.
Yes, sir.
Electricity bills of the petitioner, which included electricity duty, be revised. Which years electricity bills have to be revised? This is a petition filed in 97.
Yes, Your Lordship.
It's not even practical. Is it practical, sir?
It's
today, in 2022, we will start revising bills of 1995.
It's a statutory proceedings, Your Lordship. I am against an order, Your Lordship.
No. See, you have comfortably, without an interim order, carried on your affairs for the last 27, 24 years, 25 years.
No, it is only for the 5 years, Your Lordship. It is only for the period.
Whatever, sir. Let us assume for that 5 years, you have to get some 5 lakhs. All right.
Yes, Your Lordship.
For 25 years, without any difficulty, you have carried on your business.
If Your Lordship permits me, it's not a question of present or it is pre-97, Your Lordship.
Even worse. So we're now talking of 30-year-old bills.
No, it is a question of law, Your Lordship. It is not the question of bills, Your Lordship. If Your Lordships hold
everything. So we have superb questions of law. All right. Phenomenally good questions of law. But if the facts do not justify it, we will leave all those questions of law for excellent exposition in future. All right.
No, I'm not.
We must be practical also as courts. Yes. We are courts of equity. We are 226 courts. We are not going to start revisiting some electricity bill of 1992.
No. It is not. It is a question of policy, Your Lordship. It is not a question of bills, Your Lordship. It is a question of policy.
No. Come to your para C, sir.
Yes,
if you say you're giving up those prayers, then what you say is right. Come to prayer C.
If Your Lordship allows me, it is automatic para C will be allowed, Your Lordship. If Your Lordship holds that I have no right under and include
ultimately, if you decide everything and do not give you para C, does it serve your purpose?
Your Lordship, it is a consequential relief, Your Lordship.
No. So exactly. So come to para C, prayer C now.
Yes. I have gone through, Your Lordship.
And come to prayer E now.
Yes, Your Lordship. Excess amount maybe.
So now, as a 226 court, we have to be looking at electricity bills of 1992.
My humble submission.
I'm saying,
it is not.
What is this indulgence?
As Your Lordship pleases, but it is not a question of bills, Your Lordship. It is a question of policy.
It is ultimately only that, sir. These writ petitions have been filed because you felt that I should have been given concessional tariff for electricity, correct?
Yes, Your Lordship.
So that ultimately the real pinch is that. That is the real pinch.
As Your Lordship pleases. But my humble submission is that I am counting. The counter also supports me, Your Lordship.
So no effort. I'm just saying the petitioner has simply filed this petition and gone to sleep. This is what has happened.
Yes, Your Lordship.
If today we had not listed this, it would not have come up in this court for the next 10 years.
Humbly bow down.
In 1942, in 2042, you'll be arguing, sir, I want my 1992 bill to be revised on a very important questions of law.
I humbly bow down, Your Lordship. If it was not to be listed today, it would not have been listed. I bow down to Your Lordship.
So all these, by effects of time, you allow these issues to die. And because the court has listed it, you say, no, now sit and decide. My 1992 bill, instead of 5,000 rupees, it should have been 2,000 rupees. This is the point.
It is the subsidy which I was claiming, Your Lordship.
Correct. You have learned to
As
live
Your
with
Lordship,
it for 30
as
years,
Your
sir.
As Your Lordship.
You say this is a petition filed way back on 19 February 1997. That is more than 25 years ago. Claiming that the petitioner unit, which is a hatchery, belongs to the single quotes industrial category and not the single quotes commercial category, and therefore is entitled to get the benefit of concessional electricity tariff as is applicable to a single quotes industrial unquote unit. In the last 25 years in this petition, there has been no interim order passed by the court. The petitioner has continued paying the electricity charges on the basis of it being a single quotes commercial unit. No attempt has been made.
May I interject one thing, Your Lordship? There are many policies which has come and gone. It is under 1986 policy which I am
talking. All right. The petition was listed once on 6th May 1997 and not listed thereafter at all. Full stop. Which means for almost 25 years now, this petition has not even been listed once. Paragraph. In fact, the petition is listed today only because the court has decided to take up all old matters in their turn. Counsel to the petitioner is candid that had not the court decided to list these old cases on their own, the petitioner would not have made any effort to get it listed. Paragraph. The long and short of the above narration is that the petitioner has carried on with its business affairs as if it is a commercial unit and has been paying electricity tariff on that basis in all these 25 years.
No, that is a
Meanwhile, there have been other policy documents other than the policy document of 1986, under which the relief is being claimed by the petitioner. Stop. Today in 2022, the petitioner calls upon this court to examine the electricity bills of 1992 to examine whether and to determine whether the petitioner should be getting concessional tariff as a single quotes industrial unit, unquote. Due to sheer efflux of time, with the petitioner already having arranged its affairs in the manner indicated herein before, the court sees no reason why, in a petition under Article 226 of the Constitution, indulgence should be granted to reopen issues more than 25 years old. Full stop. The court is therefore disinclined to grant any of the reliefs prayed for. The petition is dismissed.
Your Lordship, may I only add one thing, Your Lordship? Because till now I am paying under commercial, it's not on record, Your Lordship, because many policies have come which is in my favor.
Right. If there is if any cause of action survives, it will be open to the petitioner to file a fresh petition in accordance with law.
Grateful.
Weekly list item number 2.
Let it be infructuous.
Counsel, the petitioner states the petition has become infructuous. It is disposed of as such.
Weekly list item number 3.
I permitted to withdraw, my lord, with a liberty to file on press.
No liberty, sir. It's a 1997 matter.
Yes, my lord.
Counsel, the petitioner seeks leave to withdraw this petition. Dismiss this petition.
In this case, I am appealing for the Paradip Trust.
All right.
Weekly list item number 4.
Your Lordship, infructuous.
Counsel, the petitioner states that this petition has been rendered infructuous. It's disposed of as such.
Weekly list item number 5.
But item 5, actually, there is an interim order, 6/12/2001. It still continues, but I think the electric line must have been diverted in the meantime. Therefore,
all right, we'll say it's infructuous. Counsel for the senior counsel, the petitioner states that due to influx of time, the petition is rendered infructuous. It is disposed of as such.
Weekly list item 6.
Item 6 is a single bench matter, madam.
It's okay, sir. Tell us.
And it's assigned bench is.
It's all right. Tell us what the matter is.
My lord, it's a matter which has been challenged. It's a communal land or a gochoro land which has been settled in the name of private parties, which has been challenged in this writ petition. The notice has been served but returned, and accordingly in another matter which in this writ application has been paper
So
publication
there is
has been made.
no interim order in this matter.
My
In the
lord,
last 20 years,
my lord,
no interim order has been passed in this case. The last 20 years, correct?
my lord, order has been passed, my lord.
Interim order, sir.
Yes, my lord.
When? What date?
And
What date, sir? What date? What date was the interim order passed?
15/1/18, my lord. Just
18?
15/1/18, my lord.
Let's just see what. You mean after 16 years after the petition was filed, the interim order is granted?
My lord,
So this petition was filed in 2002.
my lord.
Huh. Come in 2018, you're granting interim order like this. Have you served the opposite parties or not?
My lord, I have served. They are now residing at out of state, and that's why direction has been made by this honorable court for paper publication,
Ah.
and also accordingly in 6147 of 2002, paper publication has been made, my lord.
Not 2002, sir. Fresh notice was issued in 2018.
My
So
lord,
fresh notice was issued in 2018.
due to the death of the parties and other.
Whatever. Did
My
you
lord.
take any? Have you served them after 2018?
My lord, I've served, but that has been returned, my lord.
Sir, that is not called served. One is filing process is one thing, serving is another thing.
My lord.
Ah. So you have not served.
That has been returned, my lord. Again returned, my lord.
Ah,
For
then
that reason, that matter.
then what is this? Why are we endlessly chasing since 2002 for 20 years? What is the purpose being served?
My lord, that is a government land and villagers' land that has been settled in the name of private parties. That is the whole difficulty, my lord.
So how is even the status quo is not helping you, sir? That status quo has continued for the last 20 years.
Well, not that. That has
Why
been
should we disturb the status quo now?
My lord,
Why should the status quo be disturbed now?
my lord, that status quo in my favor, my lord. Our favor. Petition.
What is that favor? If somebody else has already sold that land and somebody's bought it, how is it in your favor? That status quo means they will continue, right? How is it in your favor, sir?
And court below's order is in our favor, my lord.
You have challenged that court below order in your favor here.
No,
What are you saying?
my lord, thereafter the appellate court has
Exactly.
My-
So the court below is not below in your favor. That is why you have come to this court.
my lord.
Ah.
There is no order for paper publication. 11/7/2018,
My lord.
direction was to take fresh notice and substitution. OP number 14. Have you
14,
taken
ma'am.
all those steps.
No, he has not taken.
14 and that has been that OP number 14 expired. Thereafter OP 15 is the legal heir of the 14, my lord. Only survived
No,
legal
no, but
heir.
where have you said that? Where have you brought that fact on record? Have you taken steps is the question, sir.
Well, I have filed a memo, my lord, on 16/8/18, my lord.
Sir, on 11/7, when it was listed before the registrar judicial, nobody appeared. You read the 11/7 order.
That is not with me, my lord.
You show him that. It's very convenient, sir. You don't have to appear. You don't have to take copy of the order. Nothing you have to do. Why should we entertain this? He's not interested at all. You say on 11th July 2018,
Thereafter, I have
the registrar judicial has passed the following order in the present matter. Paragraph. The matter is placed before this bench because no steps have been
thereafter
taken.
I have filed the memo, my lord, on 16/8/18, my
What is memo? You have to file an application, not
my
memo.
application with
What is the IA number? What is the IA number?
No, my lord.
The last mistake was 2017. After 18.
My lord, it may be taken next week.
No, no, we are not
prepared, my lord.
These are old matters, sir. No
My
question.
lord, just
No steps have been taken
my lord, just there is
by
some
filing any
difficulties, my
application
lord.
which has been
Just
numbered.
next week, my lord. Or
You file
1
for
or 2
restoration,
days,
we'll
my
see.
lord.
We'll see how serious you are.
1 or 2 days, my lord.
No, no. The court is not inclined to grant any further indulgence in matters of this nature, which is more than 20 years old. The petition is accordingly dismissed for non-prosecution.
Weekly list item number 7. Item number
Can I
7.
please take a passover
All right.
on behalf of my lord?
All right, all right.
Weekly list item number 8. Weekly list item number 8.
None appears dismissed for non-prosecution.
Weekly list item number 9.
May I tell us? This is the case. The land was acquired for the purpose of expansion of National Highway NH5 way back in 2001, my lord. Public notice was publication under section 3 GS3 of the Act, my lord. On 36/2001, as per annex published on notification in the Delhi Samaj.
So you have to go under section 18 for a reference.
No, no. What happened in this case?
If you are unhappy with the value of the structures.
No, I am not on that.
No, you may not be on that. Come to the 23rd July 2003 order. 23rd July 2003. There's
Yes,
an order passed by this court.
Or passed by the court, my lord.
Kindly read that order.
Yes, ma'am. Mr. SP, Mr. Land Counsel for the petitioner issue notice to the opposite party 1, 2, 3 by registered post to 80, returnable within 6 weeks. This petition states that although there is a structure over the Swangsho in plot number 18 under Khata number 590, this is the land was acquired under the NHI Act, my lord.
So kindly read the whole
Yes,
thing,
ma'am.
please.
Decimals of the land. The valuation of the said structure has been shown as nil by the land acquisition officer, National Highway NH Bhubaneswar Khordha in his award dated Swangsho to the writ petition, and the opposite party are now going to demolish the state structure. In view of the said submission, we direct that the interim measure, the Tahsildar Bhadrak will depute an Amin and the competent authority and the land acquisition officer, National Highway number 235 Bhubaneswar Khordha will depute a valuer for the purpose of locating the land acre 0.01 decimal in plot number 1453 under Khata number 593 and acre 0.02 decimals in plot number 1455 under Khata number 594 and evaluating the structure, if any, on the said land. We further direct till such valuation, the structure standing thereon will not be demolished.
So the only issue was valuation of the structures, correct?
Yes, valuation of the structure.
What is the remedy in a land acquisition matter if you are unhappy with the valuation? What is the remedy?
In Land Acquisition Act is not applicable to the National Highway Act as per the old
Sir,
Act.
I am not talking of Land Acquisition Act. In a land acquisition matter, I said. All right. Even if it is under the National Highway Act, if you are unhappy with the valuation, what is the remedy available?
There is an arbitrator that should be referred to the arbitrator, my lord.
Why have you not invoked that remedy?
No, what happened? I am just clarifying the position. When the case was filed, you will see in previous occasion another writ application was filed, that is bearing number 5481 of 2002, where it has been the award has been passed. Thereafter, they didn't pay the award amount. I am not opposing. They didn't pay even the award amount. Thereafter, they have filed the counter affidavit. Your lordship, kindly go through the counter affidavit filed by the opposite party number 1 and 2. My humble submission before this honorable court, paragraph 6 of the opposite party, sorry, paragraph 10 of the counter by opposite party number 1. What they have stated. My lord, I am reading paragraph 10, middle portion. However, in the meantime, National Highway Authority of India had informed that they may not require the land for the project and are interested to deacquisition of the land plot pursuant to which payment of compensation of the petitioner was withheld. My humble submission, they have filed the counter affidavit. This land is not required for the purpose of the National Highway. Though the land was acquired in 2001, now we are in 2022, my lord. They didn't pay the compensation, but the land is still in seized position by the National Highway. I cannot use that land because when the acquisition was made, your lordship knows, when the acquisition notification is there, I cannot use the land. They have stated another interesting thing I am reading. When the matter stood thus, the petitioner has filed a writ application before this honorable court bearing WPC number 5481 of 2002 with a prayer to determine the compensation money in lieu of acquired land and make payment to him. The honorable court has been pleased to pass an order dated 25/4/2003 to communicate the hour passed to take steps for the acquisition of the suit land in accordance with law and to pay the compensation if the same is not permissible. In compliance to the said order of the honorable court, the hour passed and communicated to only the communication has been made. In other day, this honorable court also asked whether the hour which was passed in favor of the petitioner, where is that? Whether they are kept in the fixed deposit, whether they are kept in a bank account, that has been asked, and the personal appearance was made by this honorable court to the officers. And paragraph 11. Then on receipt of the proposal for reacquisition from Project Director, National Highway Authority of India, Bhubaneswar, via his letter number 2424 dated 8/10/2003, report was submitted to the central government by letter number 959 of 26/10/2003 and 116 of 24/12 through Project Director, National Highway Authority of India, Bhubaneswar, which is still awaited. There is a proposal for denotification that has not made since 2003. They are awaited whether the notification has came or not. I don't know. They didn't file even if in 2018 they file an additional affidavit. You'll also go through where it has been stated the proposal is awaited since way back in 2003, my lord. That's why this honorable court asked whether the hour which was passed in favor of the petitioner, where it has been kept, whether it has kept in the bank account, whether it has been kept in any other account, whether the interest is accrued or not. That has to be, they have not specified in the additional affidavit filed by the NHI. Another thing also, kindly see, the same plea also taken by the opposite party number 2 in his counter affidavit, paragraph 6-7. There is a proposal for denotification, but that has not been made. Neither the payment has been made, nor the notification proposal has been accepted.
They have not yet taken over the possession. So how?
No, my lord. You also can see, even if they have not taken over the possession, my personal interest I cannot use because I want to mortgage the property before the bank. Can it be possible? No. When the acquisition has been made, this property has been seized and vested under the central government, my lord. I cannot use because no, they have already taken possession. What they have stated, because my humble submission, they have already taken. Another thing is that this is the expansion of 6-lane national highway. Now the 8-lane expansion highway from Chandigarh to Baleshwar is going on. They have already taken possession, my lord. They have already taken possession.
No, your land they've taken possession.
In what they have stated, in that they have stated that
you know, sir, you know whether you're in possession or they're in possession. What is the correct position?
Now for the national highway 8-lane project, they have already taken possession.
So should we record that your land they have already taken possession?
Yes, well, they have already taken possession. What are my instructions?
All right. What is your stance, sir?
My lord, I had filed one affidavit at flag Y, my lord.
Right.
There we have sought for report from Tahsildar. Tahsildar has stated that no possession, no construction has been made by NH. My lord, another provision in the Land Acquisition Act 24 says unless possession is
1 minute, sir. Are you governed by Land Acquisition Act or NH Act?
My lords, NH Act.
Then why are you referring to the Land Acquisition Act?
My lords, now in recently, there was a provision in NH Act that Land Acquisition Act is not applicable. That was struck down as ultra-virus by the apex court, my lords. What I submit, my lords, either if we will take possession, we will pay compensation. There is no dispute about that. We have not taken. It was not required. That is why you had not taken that. And after
he's now saying that you have taken possession. What is the factual position on the ground?
Tahsildar report is not taken possession, but my instruction is my photographs is there also with me.
This affidavit that is C1
Lord, see, this matter on next week.
Affidavit I have stated that possession was not taken. And in Annexure 1,
why don't you denotify that one?
Yes.
Denotification has not been made.
Why not?
In 2001.
Why should he suffer? You don't want the land? For the last 18, 19 years, no need denotification also.
My lords may direct either.
Why should we direct? Why have you not done it?
My lords, it is laches on the part of the officer. It changes, my lords.
Who is your officer instructing? Ask him to remain present. Who's the
My
officer?
lords, my lords, she was present, the land use was present and filed affidavit.
So ask him to remain present here, sir. Is the same officer still present?
No, another officer.
Who's the present special land acquisition officer?
I have to take instruction, my lords. It's a very old matter.
No, it's not.
My
It
lords,
was filed in
another-
2018, sir.
My lords, the project has been changed. It was under the PIU.
No, who's the special land acquisition officer now?
I'll ascertain and tell.
We'll pass it over. You better ascertain. We want that person to be present. We're passing it over, sir. You better ascertain. Yes.
Weekly list item number 10. Weekly list item number 10.
I am for the opposite party, my lord.
All right. None appears to discuss no prosecution.
Weekly list item number 11.
May it please, my lord. My lord, way back in 2004, Jagannath Temple Act Section 16(3) and Section 4 was challenged on the ground that lands already settled under the OE Act cannot be, that right cannot be taken away. My lord, as late as 2016, my lord, in civil appeal number, sorry, my lord, civil appeal number 7729 of 2009, filed by the Jagannath Temple, the Honorable Apex Court was pleased to quash the amendment of the OE Act declaring the Jagannath Temple as trust estate, and held that the Temple Act will prevail over the OE Act. Therefore, it has become academy. But clause 4, my lord, the Honorable Apex Court held that, may I read it out, my lord? It is reported in 2016, 1 OLR 209, my lord.
Siddha Mata case, Mr. Manti.
My lord?
Siddha Mata case, Justice Goda's judgment.
Yes, yes.
Siddha Mata case.
My lord, for we make it very clear that the striking down of the first part of the proviso to section 200 of the OE Act 1951 as mentioned above, and quashing of the notification referred to supra will be prospective, and this judgment shall not be applicable to the settled claims of the claimants hitherto under the provisions of the OE Act 1951 insofar as the lands of the Lord Jagannath Temple at Puri are concerned, my lord. So, if your lordship will clarify that Annexure 2 and 3, that is the extending the filing of the claims under the OE Act so far as temple is concerned, and filing of objection under the OE Act is concerned, if they want to settle it, the all settlements made under the OE Act prior to 2016 will not be affected. That's all that, if your lordship can give that clarification, it is all right.
This land has not been settled yet.
My lord?
The land in question in this case has not been settled yet.
And here it was a question of the general public forming an...
So in that judgment, there is a cut-off date. By that judgment, if it is settled, then it will not be reopened. If it is not settled,
right.
Then that judgment will apply.
That's right. So those lands which are already settled by the date of the judgment will not be affected.
All we'll say is that in view of the judgment of the Supreme Court, this is disposed of because judgment of the Supreme Court will now apply.
Well, they are not that part of the provision, they are not honoring, my lord. And they are proceeding with the notifications made in the way back in 1992.
This case was not listed for more than 18 years now, sir.
That's right, my lord.
So meanwhile, the judgment of the Supreme Court has come in 2016.
Yes, my lord.
The judgment will govern, sir. You say the subject matter of the present petition and the relief sought are admittedly governed by the judgment of the Supreme Court in dash versus dash.
In Jagannath Temple Act, the Jagannath Temple Administration versus Siddha Mata.
Versus Siddha Mata.
Jagannath Temple Managing Committee.
209 and the petition is accordingly disposed of in those terms.
Your Lordship, the persons if have a subsisting claim may agitate it in appropriate forum.
All right. Persons who have any subsisting claims will agitate their grievance in appropriate proceedings. All right.
Oh, license.
Weekly list item number 12.
None appears. Dismissed from normal section.
Weekly list item number 13.
Here, my lord, this kit application, I just for date check, my lord. Into the next steps, my prayer is, my lord, at page 14, my lord, to cause is therefore especially prayed that in view of the submissions made above, this honorable court may be pleased to issue rule nation calling upon the opposite parties to show cause as to why a writ of certiorari or mandamus or any other appropriate writ shall not be issued, setting aside the order of the learned Central Administrative Tribunal Cuttack under Annexure 5 being void ab initio, and the petition will not be posted as Deputy Station Superintendent in the station in the Chakradharpur division of the Southeastern Railway, and the opposite partner of 5, Sri Kalo, be transferred back to Sambalpur division to the post of petitioner was holding before his transfer to Chakradharpur division, and further why all the consequential financial benefits should not be granted to the petitioner. My lord, short fact, this is my prayer, my lord, and in my, I admit, my lord, there is no interim order. There is no interim order.
Mr. Bose, the factum still survive.
My lord?
The factum still survive. 2004 matter.
Yes, 2004, my lord. That I have not picked up. But the difficulty is, my lord, the person on the basis of whom person is, my lord. Pardon, my lord.
No. Body
transfer, they are also promoted in a separate senior.
My lord, kindly turn to Annexure 4.
So how old is your petitioner now, sir? How old is the petitioner now?
At the time of filing, he was 43 years. 43 years.
How old is he now, sir?
18 years. He must have written.
61.
61.
Just come to the prayer in your note. Have you seen the prayer?
Yes, sir. No, that is why all the consequential financial benefits.
No. Come to your prayer, sir. Come to your prayer in this note.
In the prayer, madam.
In your note which you handed over,
yes, madam, yes.
You put down some prayer.
Yes. To satisfy the order of the cat under Annexure 5, petitioner be posted as Deputy Station Superintendent.
So when he's 61 years old, we can post him.
No. In the when it appears to my lord.
No. You are handing over this note in 2022.
And I'm stressing my lord. Yes, my lord. Yes.
He can. When he's 61 years old, we'll pass a mandamus to put him as station master.
Consequential benefits, financial benefits.
Why have you put this down then? And you are asking us to transfer back some OP party number 5 in 2022. Sir, what you write here, certainly you should know the consequences of writing these things, correct?
Main deed application have stated.
No, so you can't mechanically, you are handing over a note in 2022 to us. You have to be mindful of what has happened in the meanwhile, correct? The man is 61 years old. How do we now post him in Chakradharpur's division?
No, my lord.
I mean,
he may not be posted, my lord. He may not be posted. Well, consequential benefits, financial benefits may be granted. That's what I placed. I'm sorry that I have not stated there in the date statement. Because on the, my lord, may permit to mention, on the basis of Annexure 4, my lord, person page 61, my lord.
Yes.
This is can you turn to page 63, man? Page
Yes.
63, operating portion. Considering the aforesaid facts and circumstances, the following options have left: cancellation of mutual transfer order and sparing you back to Sambalpur in former post without disturbing your seniority in the Sambalpur division, or you will be posted as ASM in the entry grade in the scale of 4,500 to 7,000 on reversal, treating your application as on request transfer, as there is no provision on transfer on intermediate grounds as per the extant rules. Your seniority will be placed at the bottom of the scale of rupees 4,500 to 7,000 from the date of your juniors in the Chakradurpur division. Your option of Ranchi division will also be cancelled since you have exercised your option for transfer from Chakradurpur division to Ranchi division in the scale of 5,000 to 8,000. Here, I'm penalized, madam. On the mutual transfer, the person on the basis of whom I have joined at some in his post, in the meantime, he was promoted. He did not apply for cancellation of his mutual transfer order. He got promotion, and when his transfer order was going to be disturbed, my lord, he seek the relief under CAT at Cuttack without making me a party. I was kept in dark. The railway authority also kept me in dark. After he got promotion, subsequently I was allowed to join in his post, my lord. And now I am penalized as because I have since my mutual transfer order was accepted, my lord.
May I submit, my lord?
Yes.
In our counter, we have specifically taken a stand.
Yes.
He was transferred to Ranchi division in the scale of 5,000 to 8,000, the
Yes.
grade in which he was working in Sambalpur division. So whatever grade he required to get it, what my senior has stated before my lord, it was already been protected. If anything left, then he can submit the application for the authority. If he is entitled to get, he can get it.
Because, my lord, in annex, and I filed a rejoinder, in that is annex 11.
But it is above to para 9.
Hello?
Counter affidavit. Sorry, my lord, I don't have a page marking. Page 6. Below to that, there is a page marking. The running page we don't have. In our counter is a page 6. Above to para 9, it was stated.
No. Why was his promotion denied to him? That is his point. Others junior to him have been appointed as deputy station superintendent, whereas he continues as assistant station master. That's the question he's asking.
Well, but the thing is this: when they are submitted a mutual application for transfer, in that period of time, the Mr. J.K. Kalu, who is the OP number 6, he was promoted. He was asked for deputy superintendent level, and he was appointed in that post, and he was posted in Jharsuguda. His claim is that because we are going to mutual transfer, he has got promotion. I will enter to get it. What he is according to his posting and his level.
No.
He must have. I don't have that.
No.
He must have getting.
You have the rejoinder affidavit, sir.
Yes, ma'am.
Mr. Pari.
My lord.
Come to para 5.
Who don't have that copy, my lord?
Yes.
We have the counter which was filed by the railway. That is with me.
Rejoinder was filed way back, sir.
2007.
2007.
On
Just now,
10th July 2007, I have copy of the rejoinder was filed. Served.
He must have served the railway council who is earlier appearing. Maybe.
Even in that para 8, Mr. Padi, which you are referring to, you have stated 2 options were given since he did not opt for one of the options. In the same cadre, he was sent to Ranchi to the same salary.
That's why I am submitting to my lord that
salary ASM, although he was posted as SM.
SM.
or Lordship may keep it to some other day. I will take the proper instruction and I also collect the copy of the rejoinder from my senior.
I can again supply. If my Lord permits, I can again supply, man.
We're not going to adjourn these matters. These are very old matters, sir. 2004.
Very old matter. Yes, yes. I try my best to
Can't
get
go
the
on
file.
adjourning like this.
And Railway has
Mr.
admitted.
Pari will reserve orders. You file your note within a week.
Village man.
Yes, ma'am. Yes, ma'am.
Orders reserved. Notes of written notes of arguments we filed within 1 week.
I also file. Problem.
Weekly list item number 14.
No instructions in item 14, sir.
Counsel, the petitioner states he has no instructions. Court stop.
Weekly list item 15. Weekly list item 15.
None appears dismissal number.
Weekly list item number 16.
None appears dismissal number.
Weekly list item number 17.
Item number 17, there are two matters. Can I take up the second matter first, my lord?
All right.
In this matter, I am challenging the annexer 4 and 5, which are assessments and demand under the Water Prevention and Control of Oil Pollution, Sex Act 1977. Now,
Right.
these orders are applicable in nature under section 13. Under section 13 of any person of local authority aggrieved can file an appeal. So I pray to the Lordship. I'll go in appeal.
All right.
And
Counsel, the petitioner seeks leave to withdraw the present petition. Only second matter or first matter also?
I'm coming, ma'am.
1 minute. Second matter, you say counsel petitioner seeks leave to withdraw this petition with liberty to file an appeal.
Well,
as provided under sections 13(1)(3) of the
Water Prevention and Control of Pollution, Sex Act 1977.
Water Prevention Control of Pollution Cess Act.
Pardon.
1977.
Subject to limitation and subject to
No,
limitation.
of course, that will be excused if the appeal is filed not later than.
Another aspect, my lord, I will pardon, my lord. After introduction of GST, this act is repealed, but it is said by section 6 of General Clauses Act.
Appeal is filed not later than 4th April 2022, accompanied by an application for condonation of delay. Explaining the delay on account of pendency of the present petition, it will be considered by the appellate authority in accordance with law.
And also, my lord,
The interim order, subject to the appeal being filed within the time stipulated, the interim order passed with this court on 8 March 2007 will continue till such time the appellate authority passes an appropriate order in the application for interim relief to be filed by the petitioner along with the appeal. The court clarifies it as it expressed no view in the matter.
Since 17, the act is repealed. That Water PCP Act, that is no more there. Only section 6. So that is in accordance with the subject to limitation and other. If law permits, then the appeal will be entertained because that appellate authority is also no more there. Says appellate authority.
That's up to him, sir. He'll know what to do. Yes.
The first matter, the order was issued by the Annexer 1 that is dated 12/9/2000. And it was issued by me on 21/9/2000. So I prefer the appeal.
Sir. 2004.
No, man, the 4 was the order. But the order passed, the order under challenge before the appellate committee was passed in the year 2000, 12/9/2000. Annexer 1, my lord. As page 18. Page 18. What they did, my lord, it was the appeal should be within a period of 45 days, and they passed the order in the year 2004 at page 23, Mayor, saying that, page 23, Mayor, answer to page 23.
Yes.
But they say that the member secretary, third paragraph, Mayor. The member secretary informed that the assessment was made on so and so, and the date of appeal is so and so, and as such, it has been time barred for which it may kindly be rejected. Well, the order was dated, I just was shown to your lordship that is 12/9/2000, it was received by me on 21/9/2000. And I, on that day itself, I filed the appeal and it was received by them on 6/11/2000. It is admitted fact, madam. And it is within 45 days. Well, kindly come to page 11. Sorry, page 7 of the writ petition. At page 11, I have explained it. Well, kindly come to paragraph 11 at page 7 of the writ petition.
Sir, again, this authority, is it still there?
My lord,
The cess appellate committee is still there.
My lord, this is of the appeal of the 2000. By that time, it was there, and it is saved by section 6, the repealing act.
All right.
My lord, kindly come to page 7, paragraph 11. I have explained it. It is within 45 days. So I may that appeal may be revived, and I may be given a chance of hearing.
What do they say in the counter?
They say that the appeal was received on 6/11. They admit it. On 6/11, they admit it.
Where
and I say,
which paragraph?
The paragraph, my lord, kindly come to page 6, paragraph E of the counter.
And page 3. Appeal should be filed within 30 days, not beyond 45 days, my lord.
But if you received a copy only on 21st September, then it will count from that date.
No, my lord, 21st September, he has not filed appeal.
No, sir. He has received the order on 21st September.
My lord, apart from that, my lord.
No. If it is apart, can't be apart. So the 45 days will start counting from 21st September. If 45 days is counted from 21st September, then even if you receive the appeal on 6th November, it is within time.
Filing of appeal was 11/10, not 21. 11/10.
Even then, it is within time, sir. From 21st September, 11/10 is within 30 days.
Appeal dated 11/10. 21st September, he filed a review. That was rejected on merit.
He says he received a copy of the order dated 12/9 only on 21st 9. So the period of 45 days will start running from 21st September.
Yes.
You say the impugned order of the appellate committee cess of the cess appellate committee, State Pollution Control Board, Orissa, Bhubaneswar, dismissing the petitioner's water cess appeal number 20 of 2000, proceeds on the basis that the said appeal filed against the order dated assessment order dated 12th September 2000 is time barred. Paragraph. It is asserted in the writ petition that the assessment order dated 12th September 2000 was received by the petitioner only on 21st September 2000. On that very date, the petitioner filed the review petition and thereafter filed the appeal on 11/10/2000. In fact, this is admitted by the opposite party in its counter affidavit, where it is stated as under open quotation, in the instant case, the due date of filing of appeal was 11/10/2000 and the appeal filed by the petitioner was received by the board on 6/11/2000, unquote. The 45-day time limit has been calculated by the opposite party from the date of the assessment order, that is 12/9/2000, and not on the date of receipt of such assessment order by the petitioner, which is 21/9/2000. There is no denial by the opposite parties that the petitioner received the assessment order dated 12/9/2000 only on 21st September 2000. If the 45-day period for filing the appeal is computed from 21st September 2000, then clearly the appeal received by the appellate board on 6/11/2000 was within time. Since there is no dispute on these facts, the court sets aside the impugned order dated 15th April 2004 of the cess appellate committee. and restores water cess appeal number 2 of 2000 to its file paragraph. Although the act under which the appellate committee functions as itself stands repealed, there is a savings clause under which all actions taken while the act was in force will stand saved. To stop in that view of the matter, the water cess appeal number 2 of 2000 will stand revived and will now be disposed of in accordance with law.
20
of 2000, correct. The petition is disposed of in the above terms.
Weekly list item number 18.
And saving, I mean, partner, saving clause is not there. Section 6 of the general clauses.
Yeah, all right. There's a savings clause in the form of Section 6 of the General Clauses Act 1897. All right.
Item 18.
Item 18, the collector's order is challenged. That is applicable before the commissioner.
But here
let him file.
Closer and the license is not renewed. Lordship's covered order is. Why should again we'll go after? Lordship last week has passed orders similar. I've corrected Lordship's date and
all right. Same order. Same order.
Weekly list item number 19.
Your Lordship, item number 19, our names may be deleted. The brief has been transferred. The names of Mr. Misra and associates be deleted, my lord.
All right. Then at request, the name of Messrs. S.P. Mishra and associates is deleted. None appears for the petition. This is not possible.
Weekly list item number 20.
No counter is filed. It is not at complete. Anyway, by lapse of time, it became infructuous.
Counsel, the petitioner states by lapse of time, it has become infructuous. Both petitions are disposed.
Weekly list item 21.
21, my lord, may I prevent the Lordship dispose of the same if any cause of action survives?
No. Counsel for the petitioner states that no cause of action survives. Petition is disposed of.
Weekly list item 22.
Liberty, Lordship, liberty granted because
No, sir. It's a 2006 matter. No
yes, madam. But that is what I remember, madam, because the CAT has a lacking the jurisdiction. He has
right,
some court. Thereafter, the CAT has a conferred.
If somebody is really agreed, they'll anyway file a petition. Yes.
Item 22.
22, my lord, no instruction.
No instructions. It is disposed of.
Weekly list item 23.
23 not pressed, madam.
Not pressed. Disposed of.
Weekly list item 24.
May it please your Lordships. Whereas the facts of this case are opposite to the facts which I argued on 28. That there it was a new industry going for expansion, modernization, diversification. Here an existing unit going for expansion, modernization, diversification has been deprived of enjoying the cell tax incentives. I'm giving the IPR. I'm giving the Industrial Policy Resolution 1996. Lordship will, the petitioner before Lordship purchased an unit at Kutra in the district of Sundargarh, my lords, by virtue of an order of the BIFR. Lordship will kindly turn to Annexure 2 at page 14. Annexure 2 at page 14, it is mentioned there that the unit was sold in an auction and it was purchased by the petitioner. Located at so-and-so Telangana, District Sundar is an industry under the medium large scale industry for manufacturing of Portland cement, aluminum cement. This is to certify that Shiba Cement Limited Unit 2 has taken over the erstwhile IFISP Cement Company Limited under the rehabilitation package sanctioned by BIFR in case number 87/91 dated 25/2/97 located at Telangana for manufacture of Portland cement. Then, my lords,
After purchasing it, the transferred unit went into production with effect from 98. That your lordship will kindly see Annexure 3. I have been given a certificate in provisional by the Diet of Industry, my lords. Then again Annexure 3A, it was amended, and again another certificate was given by the Director of Industry. And my expansion modernization, after which my turnover increased, has been acknowledged by the Government of India in the Ministry of Industry and Commerce Annexure 4 at page 19, my lords. May kindly see. To Shiva Cement Limited, this is the proposed capacity, 81,500 tons. Existing capacity so and so tons, total capacity it is given. Then, my lords, by the Annexure 5, since I was in the pipeline industry, to get the incentives, I was asked by the DIC to submit a checklist. The Annexure 5 at page 20. Lordship, may kindly see. I am to say that the name of your unit has been submitted by government for inclusion in the list of pipeline industry as on 1/1/2000. Why this was done? Because the incentives under the IPR were withdrawn by a notification of the government, gazetted notification, that is Annexure 14 at page 42. And I take your lordships to page 43 of that notification, where a proviso has been there, provided further that the industrial unit, which is in pipeline as on 1st January 2000, shall be entitled to incentives under the said notification with the same terms and conditions applicable to whom if they fulfill the following criteria as on 1st January 2000. So my name was also included in the pipeline industry. Then, my lords, right, Annexure 6. I submitted my checklist that runs from page 21 to 25, my lords.
So you started commercial production prior to 1st January 2002.
2002. Yes, 2000.
Because you started commercial production on 24 December 2001.
Yes, my expanded unit.
Yes.
Lordship, may kindly see Annexure 8. Lordship, may kindly see Annexure 8 at page 26.
Yes.
When the GMDIC requested the DI to issue the certificate, I am to say issue of subject is issue of revised commercial production certificate in favor of Shiva Cement Limited at so and so place. I am to say that Shiva Cement Limited Unit 2, Village Telangana, is a medium scale industry which started commercial production with effect from 4/3/98 after taking over the erstwhile SP Cement Limited under the rehabilitation package sanctioned by the BIFR, case number so and so. The commercial production certificate has been issued in favor of the unit by Director of Industry, Cuttack, by letter number so and so, dated 1/3/99. As per the production certificate, the finished
basically, so the DIC supports your case.
DIC supports my case.
So the sales tax authority is not going by the
No,
DIC.
not the sales tax, my lords. Not the sales tax. What has happened, my lords, after this, my lords, I submitted my application to the DI to issue me the certificate.
Eligibility certificate.
Eligibility certificate. That is Annexure 11. Again, the DIC has requested issue of eligible certificate. Lordship will kindly see page 36. Annexure 11. Since I am in the pipeline industry, I am supposed to avail. I am entitled to avail. There also.
So the general manager writes to the DIC.
General manager DIC writes to his
boss,
higher authority, boss. Then, my lords, the Director of Industry under Annexure 1
says he cannot issue.
Cannot issue. And Lordship will kindly see there was a delay in disposal of the my application. So I approached this honorable court. Lordship will kindly see page 6, para 7.1.
Yes.
That since no action was taken in petitioner's application for grant of eligible certificate, the petitioner was forced to approach this honorable court by filing a writ petition which was registered as 9586 of 2006. This honorable court, by order dated 27/2006,
So basically, a direction is issued to dispose of your application.
Yes, this court said to dispose the next page. Lordship may kindly see in the page 7, para 5 of this honorable court's order. In that view of the matter, we direct the OP number 2 to dispose of the petitioner's application for grant of eligible certificate as early as possible, preferably within a period of 4 weeks from the date of production of the certified copy of this order. Now, when I produce this order, he has rejected my application by saying that government has secretary to the government in the industry department has asked not to issue any certificate to the industries which are in pipeline.
Anyway, so who's for the other side? Because no counter has been filed.
Well, I was engaged as special counsel in this case. But unfortunately, in spite of a repeated approach, direction has not been able to give me a counter.
All right. Then we'll just go with the basis of the documents.
My lord.
All right.
But one thing I will tell you, Lord, there is no dispute in the pipeline industry. He has applied as pipeline industry, there is no. And now Annexure 1 is claimed and rejected by the direct industry saying that government has stopped not to grant the industry. My lord knows there is no estoppel against the law. And the government has the right to withdraw the exemption already granted. That
No, there is a proviso there. See, he's going by your own policy.
Yes, my lord.
The policy provided for a proviso, that notification.
I don't dispute that. Now the question is whether the Annexure 1 is the question.
He's trying to enforce your own notification dated 17/2/2000.
Yes, I cannot say against it. Now the question is, minors have decided this honorable court, so as the Supreme Court, that the exemption promised, there is no, it can be withdrawn.
No, but here you are not withdrawing, sir. Under your notification, you are giving an exemption. Just come to your 17/2/2000.
My lord?
17/2/2000, page 43, sir.
My lord, I am reading that. Page 42.
43, sir. 43.
41 says, now therefore exercise the power of conferred on the Sale Tax Act, state government is hereby direct that no exemption from payment of tax.
Now turn over the page, sir.
I am running. And allowed.
Sir, just turn over the page, second proviso.
Second proviso. Provided that the industry which is in pipeline as on 1st Jan 2000.
Yes.
2000 shall be entitled to the incentive.
And he has been given that certificate. He has been told that you are a pipeline industry as on 1/1/2000.
And the government has refused to give any certificate to the industries which are in pipeline. That is Annexure 1.
I have no answer to that.
Right. Yes. You say the short prayer in the present petition is for a direction to quash a letter dated 28 September 2006, issued by the district director of the industries Orissa, bracket opposite party number 2, declining the petitioner's application for grant of an eligibility certificate for sales tax exemption in terms of the Industrial Policy 1996, on the basis that the petitioner industry is a single quotes pipeline industry. Paragraph. In the impugned order, opposite party number 2 has referred to an order dated 11th May 2006 of the Industries Department, Government of Orissa, in terms of which it had been decided, open quotation, not to issue any further eligibility certificate for the industries in pipeline, unquote. Paragraph. That the petitioner is a pipeline industry stands acknowledged by the DIC Sundargarh, which wrote to the Director of Industries on January 20th, 2006, pointing out that the petitioner had taken over the erstwhile IPI-SP Cement Company Limited under a rehabilitation package, and that eligibility certificate for exemption of sales tax had been issued on 28 July 2000 under ITR 1992. An amended eligibility certificate in favor of the unit was issued on 31st July 2004. Paragraph. Subsequently, the unit had taken up expansion under IPR 1996, and a revised commercial production certificate was issued on 8 December 2005 with an enhanced installed capacity. The fact that the unit had started commercial production with effect from 24th December 2001 has been accepted by the DIC Sundargarh. Paragraph. Mr. Rai, learned counsel appearing for the petitioner, has drawn the attention of the court to the Finance Department notification dated 17 February 2000, whereby even while the state government directed that no exemption payment of sales tax on purchase of raw materials, machinery and spare parts, packing materials and finished products by any industrial unit shall be allowed, a proviso was introduced whereby an industrial unit which is in the pipeline as on 1st January 2000 would be entitled to the incentives as long as they fulfilled the criteria specified therein. Paragraph. Mr. Rai further points out that the petitioner satisfied each of the above criteria, and this was again acknowledged by the
GMDIC.
Sorry?
GMDIC mallards.
Which page is that?
Mallards, Annexer 11.
Annexer 11, sorry.
Annexer 11, page 36.
No, you showed me another thing where it says before this, you showed us another document.
Yes. Just a second, madam. That I am in the pipeline. That is Annexer issue of revised. Annexer 5 at page 20, mallards.
By letter dated 28 July 2003 of the General Manager DIC Sundargarh.
Name of a unit has been submitted.
Where it was mentioned that the name of the unit had been submitted to the government for inclusion in the list of pipeline industries as on 1/1/2000. Paragraph. Despite notice having been issued in the present petition way back on 18th March 2008, till date, no reply has been filed. In other words, the averments in the writ petition stand as such without any contradiction. Learned counsel, Mr. Mohanty, learned senior counsel appearing for the opposite parties, states that
Mr. Patnaik,
Mr. Patnaik, sorry, states that he has received no instructions in the matter, and therefore the factual assertions of the petitioner satisfying the second proviso to the notification dated 7th February 2000 is unable to be disputed by him. Paragraph. If indeed the petitioner satisfies all the four criteria specified in the proviso, there is no reason why it should not be issued an eligibility certificate, notwithstanding the order dated 11th May 2006 of the Industries Department. Paragraph. In that view of the matter, the impugned order dated 28th September 2006 is hereby set aside, and a direction is issued to the opposite parties to issue the necessary eligibility certificate in favor of the petitioner to enable to avail of the sales tax exemption for the period in question. The petitions are the necessary orders be issued not later than 4 weeks from today. The petitions allowed in the above terms. No orders is to cause.
Obliged. May I say one word? Annexure 1 itself refers to one government notification of 2006.
We have said that it will be issued notwithstanding. We have just dictated that, sir.
That was at 2000.
No. We have said it is notwithstanding this 2006.
No, that was in 2000. Last annexure was 2000. And this is of 2006. There is change in policy. That was a 2000 notification. Annexure 1 refers to government order that 11/6/2006. That was 2000. That's why I have not said. I have not filed counter. This was a decision of notification 2000.
Anyway.
And this has been superseded by 2006 order of the government enjoying not to issue pipeline.
To the industries in the pipeline.
Yes.
It is not a change of policy.
Not to.
Item 25.
Obliged.
Weekly list item 25.
None appears.
Weekly list item 26. Weekly list item number 26.
None appears. Just not possible.
Weekly list item number 27.
None appears. No.
Weekly list item number 28. Weekly list item 28.
None appears. Just no possible.
Weekly list item number 29.
29, may I please your lordship, my lord? Your my lord, the petitioner already dead, and I have already filed a substitution petition.
All right.
That is.
That's allowed, sir. Carry on with the matter.
My lord, may I pray one thing, my lord? If your lordships permitted me to withdraw this writ application and to liberty file a suit, my lord.
Sorry, and
to
liberty to file a suit.
I see. Counsel to the petitioner seeks leave. Substitution application is allowed. In the main petition, you say counsel to the petitioner seeks leave to withdraw the present petition with liberty to seek other appropriate remedies as may be available to the petitioners in accordance with law. This post office is withdrawn with liberty is paid for.
Weekly list item 30. Item number 30.
Item number 30 may be permitted on behalf of Mr. Mohanty. Lord, item number 30, my lord, may I be permitted on behalf of Mr. Mohanty, my lord, for the petition?
Yes.
Yes, my lord. Here, my lord, the passed by the Labour Court under 33C2 proceeding under Annexure 3, my lord, directing the OLIC Corporation to pay the arrear an arrear amount of rupees 1,21,691 to the workmen is under challenge, my lord. That order is at Annexure 3, my lord. Here, my lord, pursuant to a VRS scheme being floated by the corporation, the workman has applied under that, and he has been given the VRS benefits, and he has taken VRS in 2003, my lord. 4 years thereafter, his wife has filed the application under 33C, my lord, stating that the workman is entitled to the revised scale of pay. Hence, grant me the arrear. Here, my lord would see the VRS scheme itself, where it says that the ex gratia and all will be calculated notionally taking into the...
Sir, she has not been served, sir. That opposite party number 2 has not been served till date.
My lord, I'll take fresh notice.
No. 2008 matters, sir.
Yes, my lord. Then I'm placing the matter.
You should have followed up. You should have made sure she's served, sir.
My lord, may I permit to take fresh notice, or my lord, I'm ready with the matter?
You can argue the matter. Anyway, she has not been served. Yes.
Yes, my lord. Here, my lord, the fact remains that in 2003, that workman has taken VRS.
It's all right, sir. Her wife may not know all these niceties.
Yes, my lord. Then the VRS scheme itself says that the ex gratia will be calculated notionally taking into consideration the revised scale of pay. That he has been granted with.
Let's see the impugned order award. Which page is that?
Page 16, my lord, Annexure 3.
Yes.
This is a case originated out of the claim entertained by the petitioner for realization of the arrear amount on the basis of the revised...
You did not even participate, sir.
I filed my counter, but on the date of...
You did not participate. You stood...
I filed the counter. That was on record, my lord.
That's all right.
My lord.
But you did not participate.
Yes, my lord.
My lord, not appearing. What is the reason for not appearing?
On the date of hearing, I couldn't appear, but I pray that I have mentioned all these notifications, the VRS scheme, all I have produced in my counter. That has not been taken into consideration by the Labour Court. The scheme itself says that the ex gratia will be calculated notionally taking into consideration the revised scale.
Not a substantial sum also. It's not even a substantial sum. You know.
Well, now there are many workmen who has taken VRS scheme. My lord, it will have.
They will say it won't be treated a precedent. That's all. The council, the person petition has been filed, charging an award dated 20th March 2008, passed by the Labour Court, Jaipur, Koraput, in industrial dispute, miss case number 58 of 2007. Paragraph by the impugned order, the Labour Court has allowed the application filed by the opposite party number 2, the wife of the deceased employee of the petitioner, for realization of arrears on the basis of a revised pay scale with effect from 1996. Paragraph. Resisting the above application under section 33C, bracket 2 of the Industrial Disputes Act 1947, bracket ID Act, the present petitioners had filed a reply contending that under the voluntary retirement scheme, bracket VRS, bracket, the deceased employee had already been paid his entire dues, and this took into account the possibility of pay scale revisions in future. Paragraph. As it transpires from the impugned award, the present petitioners, who were opposite parties before the Labour Court, choose not to participate in the proceedings, and the impugned order was passed ex parte. Full stop. There is no reasonable explanation offered by the present petitioners for remaining absent from the Labour Court. In the circumstances, the impugned order, proceeding on the basis of the petitioner, the genuineness of the claim of opposite party number 2 herein, cannot be faulted. Paragraph. It is then contended by Mr. Paddy that the impugned order might constitute precedent, as there were other employees who received VRS and who might now raise similar claims. It is clarified that the impugned order would not constitute a precedent in other cases, each of which would have to be considered on their own merits. The court is therefore not inclined to interfere with the impugned order of the Labour Court. Petition is dismissed in the above terms.
Weekly list item 31. Item number 31.
I'm for the OP, my lord. OP number 3.
All right. None appears dismissed. Not
Weekly list item 32.
32, my lord. In this case, writ application, my lord, the order of in the OA revision case passed by the member board of tribunal is under challenge. The OA revision case under Annex 4, the order passed by the member board of tribunal is under challenge. Here, the member board of tribunal has set aside the order of the OA collector, which has been settled in the year 1982 after lapse of 24 years of the OA order, my lord. This in exercising the power under section 38B of the OA Act, the
38B, correct.
Yes, ma'am.
Yes.
By
Same,
virtue of-
Ekapadia and tenant register.
Yes, that same story that Sukinda Tahsil also.
Same. You already decided many such matters, Sukinda Tahsil. Already decided. Yes.
Yes, ma'am. That annexer 1 is the land has been settled under section 8(1) of the OA Act in favor of this petitioner, my lord.
Right.
Thereafter, the collector had prepared a petition under Annexer 3, reporting that the fraud has been committed and saying that the Tahsildar has no jurisdiction to, the OA collector has no jurisdiction to decide the same.
Right.
And in this regard, the counter also been filed, my lord.
Yes.
In the counter, they have stated in para 7 that para 6 that the Tahsildar, the jurisdiction of the Tahsildar is under Sukinda, Basanagar and Dangadi, and the present revenue village is coming under Jajpur police station. This is stand is not applicable so far as the present revenue village is concerned. The OA case has been settled rightly in favor of the petitioner. And my lord, in para 11 of the counter has second the 38B, there is no limitation regarding the exercising the revision case under section 38B of the OA Act. But this petition is filed by the collector under Annex of 3 by not following the Board of Revenue guidelines, my lord, which was published in the Gazette Notification 1963. There are certain provision to refer any petition, any appeal or revision to the Board of Revenue. There is certain guidelines or principles that has not been followed while the Annex of 3 petition was preferred to the member Board of Revenue. And that about in para 10 of the counter is stated that any dispute can be referred to the civil court to establish the rights. Here the petition under section 38B is filed by the collector regarding the disputing the issues, my lord. So the direction is not applicable to go to the civil court by the petitioner, my lord. The petition is preferred by that at this scenario factors in given case, take a case that quota was obtained fraudulently in collision with the officers, and it comes to the notice of the authorities after a long lapse of time. By this stand, how the order of the OA collector will be set aside. What fraud is committed, they have stated that officer has committed. And by taking this stand long after 29 years, the OA Pata has cancelled by the member Board of Revenue by Annex of 4, my lord.
Come to para 24, sir.
24. Yes, my lord. para 24 of the
Board of Revenues
impugned
order.
order.
Page 24.
Yes, my lord. That has been stated that a confirmation of
Kindly read it. Kindly.
the settlement land under section 6(7) of the OA Act is only the ex-intermediate or temporary lease. Under him, there is no mention in the case record. The Vishwanath Kuntia was the ex-intermediary of a temporary lease under the
lessee
or a temporary lessee under him. In fact,
that is not visual. Because
You want to take our paper book? You can read it. Should we give you our paper book, sir? We'll give you our paper.
My file is also visible. I can read it.
You can neither borrow it from him or.
the settlement land under section 6 and 7 of the OA Act is only the ex-intermediary or a temporary lessee under him. There is no mention in the case record that Vishwanath Kuntia was the ex-intermediary or a temporary lessee under him. In fact, the OA collector Tahsildar Sukinda has held the Vishwanath Kuntia was accepted as tenant by the extender of Sukinda estate. This leaves us the section 8(3) of the OA Act. This section is meant for some settling some kinds of land held by the persons who were intermediate immediately before the date of vesting, enjoying it under the intermediary on favorable terms in lieu of the personal services being rendered to the ex-intermediary. The revenue inspector of the OA collector cum Tahsildar Sukinda have also not recorded any entry or
Conducted any inquiry.
Yes, ma'am.
Conducted any inquiry
and arrived at a
or sir, is it written there differently or because in our copy it says or
yes or arrived at a conclusion that settle was rendering the personal service to the ex-intermediary. Therefore, the land in question has not been settled with Vishwanath Kuntia under the section 8(3) under the OA collector cum Tahsildar has not decided the section.
Identified the section. Sir, why are you? I don't know. What's the difficulty in reading it, sir?
Sir, just I'm correctly reading. Well, sorry. Therefore, the land in question has not been settled with Vishwanath Kuntia under section 8(3) of the OA collector cum Tahsildar has not meant.
What do you have to say, sir? These are the findings against you. What do you have to say to this?
That I have not prepared the rejoinder of my letter.
No, it's all right. The petition is dismissed. We'll pass the detailed orders. All right.
Weekly list item 32.
32 only what was no?
Weekly list item 33.
I am appearing for the respondent, Mr. Rautrendra. Before my conference begins, I am for the respondent, opposite party. Your Lordship may kindly look to your Lordship's order dated 7/11/2019. A coordinate division bench, after hearing both the parties at length, had directed this with a view to, your Lordship kindly look to the order number 17. Why this order was passed, Lord? This matter is of the year 2009. And the original application before the tribunal was disposed of directing for a de novo inquiry. In the meantime, the petitioner retired in the year 2018. Therefore, your Lordship, after hearing, passed this order on 7/11/2019 with a view to come out a reasonable penalty on counsel for the petitioner request for time. That is Mr. Patnaik's client, my senior friend, Mr. Patnaik's client. And if your Lordship will look, another order, that is order at the time of admission, the order dated 24/1/2018. 24/1/2018. If you also look to that order, while you also admitted the matter, we make it clear that since the opposite party number 1, that means the present opposite party 1, has already retired from service, the petitioner had directed to calculate the retirement dues of the opposite party number 1 and deposit the same with the registry, who in turn will invest the same in fixed deposit. It is further directed the opposite party one succeed in the matter, the deposit so made in the fixed deposit account shall be paid to him. But subsequently, after hearing on 7/11/2019, this order was passed. What is the reasonable penalty? In fact, I am before my non-friend begin, I can also concede to the extent I had called by the client and I had asked him that if you suppose it will go for de novo inquiry now, 4 years back you have already retired, and you will now participate even if this order will be implemented, then what will be the result? When it will be concluded, nobody knows. So I have made my client also to agree that if your lordship will accept this reasonable penalty, whatever argument I have, that is a different thing. That argument on merit you can argue. If your lordship will look to the finding of the tribunal, that's a different question. But since your lordship had directed this counsel appearing for the petitioner to take instruction to come out a reasonable penalty, let him say, then your lordship. That is what, as an opposite party, I got your lordship. On merit, if my non-friend wants to further argue, then I have to give the reply. That's it. But this is after hearing twice or thrice, the division bench, the coordinate bench of this honorable court passed this order.
I filed a dead charge, my lord.
Yes.
The allegation is the opposite party
Yes.
misbehaved with a girl student of age 11 while giving tuition.
Right.
And on that, the principal called all of them and a apology was filed by the opposite party number 1 saying I have made the defect, I will not repeat it. Annexure 2 admitted the thing 2021/7/2007. Then there was a settlement. No, it will not be. You will beg apology and it will be settled. But the mother of the girl approached the assistant commissioner of the area on Annexure 4. He directed her to conduct an inquiry as per 81B. And accordingly, the procedure laid down as per Annexure 6. What is the methodology to do? There is a preliminary inquiry, there is a summary inquiry. My lord knows the Avinash Nagara case in these matters. And Rule 81B of the code also provides that. And accordingly, a preliminary inquiry was held in which the petition opposition did not appear. Statement of the girl was recorded. Then there was a summary inquiry in which the statement of the girl was recorded, admitted clearly, page 30, my lord see. Page 30 of the inquiry proceeding. Page 30, my kindly listen. Summary inquiry. This is page 30, my lord. Srimati Makari Maji, grandfather, were outside the room at the same house doing some work. Initially stated that started cheating mathematics while teaching. Mr. P.L. Mahanti taught the private parts breast of the Kumari Anuradha Marandi thrice. She registered with the gesture. This statement clear statement before the girl, before the summary inquiry, directed by the Assistant Commissioner. Then, on that day, and it is not meant to be to subject cross-examination, as my lord knows, or to subject her to cross-examination. Then, he also examined, the opposite party also was examined, the statement recorded. The report is given, that is under Annexure 13. Then, what is important is that the commissioner of the Kendriya Vidyalaya issued notice to the opposite party to file a show cause here. That is also in accordance with the procedure laid down for these matters. And he rushed to the tribunal. Tribunal admitted the case, should not have admitted the case. As the interview says, my lord knows Supreme decisions are there. I have given a note that you cannot interfere in this manner. And what is ultimately said, direct a fresh inquiry. How many, why do you know inquiry is there? The summary inquiry is there. Why? He says, why you are referred to the admission of guilt by the before the principal? That is not consequential. That is a matter of fact. He has admitted. He said, I gave blank paper 3 years admitted. That is a disbelief. Say, I was not there. I was not there in the station. First said, 21/7 is admitted in writing, annexure 2. I was there. A compromise was settled, that is also he has signed the delinquent. There is a teacher level inquiry that he has also, the girls are stated. In the summary inquiry, the girls are stated like this. What is the natural justice has to be done with this? Because of this, and it is a challenge against show cause notice. Now that he has retired, as per section 9(4) of the pension rules, that has been concluded. This is pension rule.
So he stalled, he has approached the cat at the stage of twins.
So even before Sogon is served.
My goodness. So even now, if we dismiss the petition, it will only go to that stage.
That stage only.
My goodness.
And
Mr. Rautre, what is the justice in this matter? You tell us. You have stalled even the conclusion of the proceedings against you.
Allow me for a moment. If you also look to page 15, paragraph 9, the judgment of the finding of the joint tribunal. How it has been dealt with by the opposite party, kindly have it.
No, but is it not premature?
It is not premature because they made a so-called inquiry, that preliminary inquiry, they admitted that the principal had no jurisdiction at all. And that too, that is an ex parte. That too, no copy has been served. No inquiry report has
participated in the inquiry, sir.
No, Milord, the second summary inquiry.
You participated in that.
That's right.
And you submitted forged documents to show you were on leave.
No, Milord, that is wrong. Absolutely wrong.
Yes.
You'll also look to that. You'll also kindly look to that. You also kindly come to page 15, paragraph, page 139, running page 139 of the brief.
All right.
You also kindly have it once. That is finding. Para 9. Having regard to the above, the argument of the Law Council for the applicant that though the alleged incident had taken place on 11/1/2007, the complaint was filed before the principal by the mother of the victim after the deliberation and discussion. That too after 10 days, that is on 21/7/2007, cannot be brushed aside. That apart, it is also a fact to be noted that alleged incident, according to respondent, had taken place in the house of the girl student, which is outside the premises of the school. However, the Law Council, appearing for the respondent, at this juncture invited our attention to 15 of the Education Code of the KVS, which reads as follows. Then you also kindly come to...
No. What is this? Look at the way they're approaching it.
Yes. The approach...
Reading of the above sub-article would show that every teacher has an obligatory and bounden duty to adhere.
Yes, sir. Yes, sir.
That by itself cannot extinguish.
No, sir. I don't deny that. That is exactly that is I accept that. That is the provision of 59(14). A reading of the above sub-article would show that every teacher has an obligation to adhere to exemplary moral character in the Vidyapita or outside, but that by itself cannot extinguish the normal rule of law to seek the legal remedy available in general law when an incident happened outside the premises of the school, and that too in a private house. In this context, it is to observe that the alleged incident having occurred on 11/7/2007, no complaint had been filed before the police either by the complainant or by her father, who was present in the scene of action. However, we are not considering this to be reason to reject the plea now put forward by the respondent against the applicant. The next question is very important. Next question to be considered is whether, after issuance of Annexure A by 5 memorandum, the applicant had been afforded sufficient opportunity to defend him. Though Annexure A by 5 dated 22/8/2007 has been served on the applicant by the same principal of the institution on the instruction issued by the Assistant Commissioner KBS R.O. Bhubaneswar, it is clearly stated therein, as per the written allegation submitted by Mr. P. Banandi, the mother of the victim, the applicant had been directed to submit his reply latest by 23/8/2007. In this context, the applicant case before the tribunal is that in pursuance of Annexure A by 5 memorandum, he filed a representation before the principal on the date fixed, that is on 23/8/2007, denying the allegation leveled against him in the complaint filed by the complainant. In this context, it is to be noted that the inquiry officer respondent 4 issued Annexure A6 order to the applicant on 22/8/2007, requiring to appear before any inquiry commission on 23/8/2007 at 12 noon in the mathematics laboratory of Vidyapita positively. It is the contention of the Law Council that after service of Annexure A by 5, there is no heed informing the applicant for constitution of the committee requiring him to appear before it, and this point has not been answered by the respondent in the counter to show that the applicant was given sufficient opportunity about the constitution of the committee or any committee constituted by the inquiry officer so as to take evidence as such. If it be so, we are of the view that after serving Annexure A by 5 memorandum on 22/8/2007 and Annexure A by 6 letter dated 22/8/2007 of the inquiry officer, sufficient opportunity was not given to the applicant to either effectively put his defense pursuant to Annexure A by 5 or to participate in the inquiry by appearing before the committee constituted to inquire into the complaint filed by the complainant, Mrs. P. Marandi. In this context, it is to be noted that the stand taken by the applicant in Annexure A by 8 that he had not been informed by any authority about the constitution of the committee or the demand of the inquiry committee. Hence, we are of the view that the alleged inquiry conducted by the committee constituted by the inquiry officer or the committee constituted for the purpose had not given any opportunity to the applicant to submit his case. In this context, it is also be noted that the applicant case is that invocation of Rule 18B of the code is not justifiable. Hence, the applicant challenges Annexure 14, order of the Commissioner KVS dated 28/5/2008, by which the charge has been issued against him by invoking 81B of the code. In this, I saw that provision word. In this context, the Land Council for the applicant submitted that the dispensation with the inquiry under CCA rules, though initiated the CCA rule under Rule 16, the proceeding was started. In the case of the applicant is not justified, as the fact alleged would warrant such a decision to be taken by the Commissioner of KVS New Delhi. To this question, the Land Council appearing for the respondent submitted that in view of the provision contained in Article 59(14) and 81B of the Education Code of KVS, the respondent are justified in issuing Annexure A by 14 memorandum. To substantiate his contention, the Land Senior Council relied upon the judgment in Appeals Court in Civil Appeal number so-and-so, supported in so-and-so, Satir Singh case. In the above judgment, the Appeals Court considered the application on Article 81B of the Education Code for KVS in dispensation with CCA and CCA rules. The normal procedure while inquiring into the complaint against the government employee. We are not taking any view on this aspect, as it is left to the authority to exercise its discretion depending upon the fact and circumstance of the case. In the circumstances, we are of the view that Annexure A by 14 remain unaccessible insofar the invocation of Article 21B of the Education Code is concerned. Next, the next point to be considered is whether the report of the so-called fact-finding inquiry committee or the summary inquiry committee, as the case may be, could be taken into account based on which Annexure A by 14 came to be issued. In this context, it is to be noted that we have already held that in the preceding paragraph that the committee constituted by the principal having no jurisdiction, that is also admitted in their counter that principal has no jurisdiction. Having no jurisdiction cannot take cognizance of any evidence and or prepare any documents, the very basis of the constitution of such committee being non-est in the eye of law. In this background, it will be advantageous to quote hereunder as to what are the findings of the inquiry committee recorded at page 6 of Annexure R by 10 inquiry report. The committee was called to the chamber on such and such date. They were asked to inquiry regarding the allegation made by so-and-so and CP Mahanti, TGT, so-and-so, misbehaved with her daughter such and such, Anuradha Marandi and such and while giving private tuition in the house at 4 to 5 p.m. When the committee entered the principal room, there were 5 more persons were sitting over the below. These are the person. Mr. P.L. Mahanti was also present there. After some questioning and discussion, P.L. Mahanti accepted his guilty that he misbehaved the so-and-so Marandi while giving private tuition at our residence on 11/7/2007 between such to such time. He gave a confession statement accordingly. Then the settlement note was prepared accordingly and signed by all members, including P.L. Mahanti. In the said process, there was no threat or pressure given to P.L. Mahanti by one present there. Next paragraph. On the above statement and evidence, the summary inquiry committee came to the conclusion, solely on the basis of this, where no opportunity whatsoever has been given to the petitioner, came to the conclusion that the complaint against the applicant had been proved under Article 21B of the Code as evident from Annexure A by 14. As has been held above, none of the document or evidence adduced before the principal or the committee constituted by him can be used by the applicant or the respondent, as the case may be, and therefore the inquiry report under Annexure R by 10 submitted by the said committee is liable to be set aside, and consequently Annexure A by 14, which is based on Annexure R by 10, is not sustainable. Accordingly, with was Annexure R by 10 and R by 14, resultantly the respondents are directed to conduct a de novo inquiry against the applicant from the stage of issuance of Annexure A by 5 memorandum after affording him a reasonable opportunity as per the rules. And if you also will look at this stage, you will also kindly look at how they have initiated the proceeding at page 16. if they have initiated the proceeding under page 16, we'll also look to that. They have initiated under Rule 16 of CCA and CCA rules. And they have not, admittedly, they have not served me the copies of the documents. They have not, the principal had no authority. They themselves have admitted in the counter because the principal had no authority. Then the whole thing is illegal that they have accepted. And then the inquiry without notice, absolutely, so far the preliminary inquiry is concerned, admittedly, there is no notice whatsoever has been issued to the petitioner. Then the copy of the inquiry report has also not been, preliminary inquiry report has also not been communicated. Then so far the summary inquiry is concerned, it will also look to the admitted fact that though the petitioner was noticed, he appeared and he prayed for 5 days time. That was refused and rejected. And immediately on the basis of the preliminary inquiry report, the summary inquiry was concluded and the order was passed. That is, at that stage, the petitioner approached the, because of invocation of 81B on the fact and circumstance case, the petitioner had no other alternative, approached the current tribunal. The tribunal thereafter adjudicated the matter, they filed the counter, and if you also look to their counter, so far the principal jurisdiction is concerned, that is at page 83. They themselves have admitted in page 83. This is their counter below. Para 8.
Is it important principal or the committee? Summary committee.
Please, I am concluding.
Sir.
Page. But in the, let's get it at page 83, running page 83. In this background, this is their counter. It is humbly submitted that the principal, K.V. Baripada, has no manner of right to issue any charge sheet upon the applicant under minor penalty, as the instant case of moral turpitude comes under Article 81B of the Education Code, and Commissioner KBS being the competent authority to take action against the applicant under Article 81B of the Education Code. Keeping in view the gravity of offence, the principal did not go ahead in pursuance of the letter under Annexure A by 13. And they themselves have admitted, now the preliminary inquiry report is being utilized against us, even without giving a copy of that. Only with the summary inquiry, they concluded everything and they have done it. And my counter, if I'll show you, Lordship, I have denied all these allegations because I was given a, Lordship, kindly look to that counter, one paragraph I'll show. So far as the allegation, that allegation is concerned, I'll just show you, Lordship, that is that page, well, that is page 100. That is counter filed by the OP number 1 before this honorable court. That is the entire case. That is after 144, last judgment where it was enclosed. Just one page after.
Page 145.
I am obliged. That with regard to paragraph 2, with regard to the amendments made in paragraph 2 and 3 of the writ application, it is submitted that complaint was made by Srimati Parvati Marandi on 21/7/2007 before the principal against the deponent, and principal made a committee to inquire the matter. Compromise was made and apology sought for by the deponent and warning was issued to him. The so-called fact-finding committee formed by the principal, in which the principal was also a party to the settlement, forced to sign on the compromise by terrorizing this deponent, and also a fake confession note. Fake confession note was made as per the design by terrorizing and saying that opposite part number 1 is a newcomer to the place and that area is an Naxalite area. It is further submitted as the deponent is a newcomer to the institution and had never been any private tuition, but he was falsely implicated in the case and on being terrorized, and the settlement was made and signed by the deponent. But this is now one thing I'll show you, Lordship, so far the provision of 81B, which they are now trying to invoke. Your Lordship, kindly look to that. That is, I've given to your Lordship that copy of that. And they themselves have initiated this proceeding under CCA rule 16(1). That means natural justice, so-called the inquiry, the evidence, everything. But they have dispensed with all this of their own, taking advantage of this 21B. So I am reading 21B. I've given a copy to your Lordship, so I have sent it today. Just I'll take your Lordship to that provision only, because the whole thing now depends upon 81B, which they want to dispense with all the principle of natural justice and everything. And even the tribunal has said 81B, they can invoke in the fact and circumstances that is depending upon them, provided they come to a logical conclusion after giving an opportunity to the petitioner. But I'm just reading your guys. Termination of service of an employee found guilty of immoral behavior towards students. Wherever the commission is satisfied, let's get it.
Yes, yes.
Wherever the commissioner is satisfied that after such summary inquiry, this summary inquiry which I have not been noticed, I have not given opportunity, as it deemed proper and practicable in the circumstance of the case, any member of the Kendriya Vidyalaya is prima facie guilty of moral turpitude involving sexual offense or exhibition of immoral sex behavior towards a student. He can terminate the service of the employee by giving him 1 month or 3 months pay and allowances according as the guilty employee is a temporary or permanent in the service of Sangathan. In such procedure prescribed, the holding inquiry for imposing major penalty in accordance with CCA Rule 1965 as applicable to the employees of the Kendriya Vidyalaya Sangathan shall be dispensed with, provided that, that's the kindly mark this, provided that the commissioner is of the opinion that it is not expedient to hold regular inquiry on account of serious embarrassment to the student or his guardians or such other practical difficulty. The commissioner shall record in writing the regions under which it is not reasonable practicable to hold the inquiry, and he shall keep the chairman of the Sangathan informed of the circumstances leading to such termination service. So far as this proviso is concerned, neither any reason has been given, nor that is the case that the commissioner has recorded in writing the regions for which is not essentially practical. Rather, here is a case I have shown your lordship in page 16 that they have initiated under Rule 16(1). They called upon to file the show cause. And so far the principal who has issued, he had no competency at all. They themselves have admitted. Then on the basis of that, they made the summary inquiry. In the summary inquiry, had they given opportunity, as your lordship said, that they would have given me the opportunity of hearing by giving copies of all documents and the preliminary inquiry report and other thing. I appeared. I said that kindly give me some time to at least with some document so that I can give my answer, my reply. But nothing was given. It was closed, and at that stage, I had to. And they applied this 81B. So I approached the tribunal, and the tribunal has passed this order. And so far, the only natural justice. But so far, that will go back to that stage for only giving me natural justice, so that that will be decided there.
All right. Order is reserved, sir. All right.
I have given my one thing. That is one.
And so far one thing I know. So far the
photocopy, sir. You give photocopy.
Yes.
One decision I have not given. That is the judgment of 2020, Supreme Court 2978. Chairman का manager Mahanadi Coalfield Limited versus Rabindranath Chaudhary. It says that
give a photocopy. You give a photocopy, sir.
My lord.
Give a photocopy of the judgment.
My lord.
But another thing also, so far as the writ application is concerned.
Other judgments I have given.
Yes, the writ application of the year 2009, and right. They obtained the interim order from here.
All right.
In fact, I moved time and again, but now interim order was not attributable to me. That at my instance, the interim order has been passed. The matter could have been concluded before my retirement.
All right.
The matter came to an end in 2018. I have retired.
All right.
So I will give a note of submission. Which,
it's already there, sir. We have it
already.
We have the note of submission.
I will give Xerox copy within before lunch. I will give.
Weekly list item 34. Weekly list item number 34.
None appears dismissal office.
Weekly list item number 35.
Miller's list 35 relates to claim of seniority of judicial officers, those were appointed in the year 2004. In the meantime, many of them has been promoted to various cadres. I was absent for 2-3 days from Cuttack. I could not take any instruction. Can it be a next week any day so that I will be due to no fault of mine, it is adjourned. This, if your lordship will see
all of them have been promoted to the DG rank. Lord, I am appearing for opposite party 15 and 17. Lord, all of the petitioners have been promoted and also all the opposite parties. Your lordship also finalized the Honorable High Court has also finalized the civil list. All the persons.
Yes, that's right, sir. Nothing survives now. Everybody's got promoted.
No, my humble submission is If my seniority will be determined, I may get little benefit.
No. The final list has now been published.
Yes.
So if you have any grievance, you file a fresh petition.
Yes.
You say, during the pendency of the present petition, the final civil list is approved by the full court of the High Court of Orissa on its administrative side has been published. In that view of the matter, reserving the right of any agreed person to file a fresh petition, if so advised in accordance with law, the present petition is disposed of.
Deeply obliged. Quickly list item 36.
Item 36, though I had challenged the order of the London Commissioner Endowment Day under Section 30 of the Orissa Hindu Religious Endowment Act, but in the meantime, this is expedient order, my lord, I had challenged, but in the meantime, I have filed a miscase to set aside that expedient order. I will pursue there and I want to withdraw this case.
Or counsel, the petitioner seeks leave to withdraw this petition with liberty to pursue a miscellaneous application filed for recall of the ex parte order, impugned ex parte order. Disposed of is withdrawn with liberty as well.
Quickly list item 37.
37, may I please, my lords? I am for the appellant, my lord. I have been informed by my learned friend appearing for the other side that the order passed in the writ application by the Honorable Single Judge, which has been assembled in this writ appeal, has already been recalled at their behest. They had filed one miscase.
Counsel for the appellant states that the impugned order has already been recalled. That view of the matter, nothing survives in the writ appeal. It is disposed of.
Yes, ma'am.
Quickly list item
In this case,
38.
I am appealing for the respondents. I am appealing for the respondents.
Item 38.
But may I please your lordship in this matter to another connected matter, in item number 11 in the supplementary list. That is the main matter, I think. All the documents and
Are
everything.
you able to hear him? Yeah. That day it came up, sir. So now both matters have to be heard. 187 was listed that day.
Yes, yes.
Today is 186. Where is 187?
187 is that supplementary list item 11.
You can take it up.
But I have a short note.
No. So we'll take
This
it
is
up
a-
together, I'm
this-
saying. 187 matter.
This is a matter regarding the transfer of fragmentation of land. Copy to list. My humble submission, I will request your lordship to have a little moment to the Honorable Justice Mahapadra, because in the ODI document, that is very important. That document, that description of property, I do not want any recitals. Can I permit your lordship to, that is annexure, annexure 4, annexure 6. 2 khata, 2 plot, comprising area more than 1 acre.
Take off your, as it is, it's not clear, sir.
Sir,
So
sir.
remove your mask and talk.
Thank you, sir. I want to take a lordship permission to just ODI document.
So all permissions granted. All right.
All right.
Don't have to ask every time.
Right.
All permissions granted.
I want to take a lordships to the description of property of the annexure 6. That is admittedly, your lordship will find from the page, running page 41. Your lordship, that is 2 plots and 2 khata. 166 Bikri plot, Chari number Chokka, Boils number Puna Virakta, 61 decibel. And another plot is in the just before
0.61 decimal.
yes, one is 81 decibel, another is 61 decibel. The cell deed, one cell deed
From 444
covers
it's
2 plot,
81. From
2 khata.
404 it's 61.
And your lordship will find from the recital of the, there is a boundary line in the western side of the plot. This page 38, the boundary also given. Running page 38. And your lordship 38 on the page of recital, page annexure 6, 38. Description of properties. Four 440 6 खाता and 42 खाता 341 by 166 सब रजिस्टर थाना 5 नंबर पटसंदरपुर मौजा खाता नंबर 341 and 166. There is 2 khata and the description is there in the western side, Paninala and Kreta, myself, in the two plots. And in the next page, in the western side, Urdanand Mandi and myself, Kreta. My humble submission to show this only, I am a contiguous plot owner of the adjoining land cell under the impugned cell deed, and also it is beyond 1 acre. The scope and ambit of the legislature that there should not be fragmentation without leave of the Tahsildar, revenue officer. So, in order to satisfy that, in other words, the land must be comprised in one parcel of land. So, I being a contiguous landowner and purchased in one cell deed beyond 1 acre. So, these aspects of the matter neither considered by the collector nor considered by the Honorable Single Judge. And Honorable Single Judge come to hold that I am in the western side of the suit plot under transfer. That is paragraph. And that is paragraph of the impugned order, annexure 4. Sir, Milord, kindly para 9 of the findings of the single judge. This, the order to judge whether the cell in question has created a fragmentation, otherwise it is apt to look, running page 29. It is apt to look into the recital of the cell deed. The copies of the cell deed have been filed contesting opposite party. In both the registered cell deed, the condition of the cell have been described, which show that brothers are recorded jointly have mutually partitioned the cell. The seller resides in the cell deed dated 26/11/2005. That out of plot number so and so 444 and chakka number 76, he transferred in area at 81 decibel, which bounded by north Pratap Kumar Badhiyari, south Parameswar Swai, east Maheshwar Naik, west Paninala, and purchaser. And since 2 cases have been filed, the another plot number and khata number has not been incorporated in the input judgment. So 2 cases has been filed. My possession with regard to the contiguous chakka owner cannot be disputed in view of the findings of the learned Honorable Single Judge. That aspect also considered by the collector. Since there are 2 chakka, 2 plot, which is situated in one complex as per the map indication, and inquiry report submitted by the RI and the revenue officer, accordingly, there is no impediment caused to any person. And who is you? The person who is the opposite party of private representative 1, as plaintiff, filed a suit before this proceeding. Filed a suit, that is annexure, your lordship, from the date chart I have given. Annexure 9, civil suit. Annexure 9, civil suit is there. After the civil suit, filing of civil suit, what is thought in his mind, I could not unable to understand. He said, I have not transferred the cell. I have not executed cell deed. It's a mortgage deed. According to the plaintiff private opposite number 1, he filed a suit as a plaintiff. And the description is there, 2 khata, 2 plots.
Anyway, single judge has held it's a sale deed and not mortgage.
That is pending.
No. Single judge has gone through the document. And if
civil
it's
judge
plain,
has
it is
not
a sale deed, it's not a mortgage deed.
No, civil judge has not decided anything.
Single judge has said, sir. Single judge, para page 31,
yes.
para 13.
Yes.
The single judge has held, these are only sale deeds, they are not mortgages.
So without evidence, oral evidence, without documented evidence, can I in a read of 226?
Sir, the recital in the sale deed will not tell us.
No.
You need evidence for that.
So that is true. That's why I am submitting
and
that.
Is it your case it is mortgage? Is it your case it is mortgage?
It is his case.
So it is not even your case, correct?
Yes, I am also saying so.
No.
I am saying so. I am saying so.
Absolutely not, sir. I don't think it was ever your case that these are mortgages.
No, that apart, I do not.
What is that apart? What is that apart? It was never your case that these are mortgages.
The second question is, once a contiguous chakka owner beyond 1 acre.
Or
The nomenclature of the deed is also.
Yeah, absolutely clear. Extent is clear, nomenclature is clear, prohibition is clear.
Both this one cell deed, both the document, both the area will come to a comprising that will more than 1 acre.
Right.
And it is adjoining to my own land.
All right.
Even your lordship will see section 34 subclause 3, certain restrictions are imposed on contiguous landowners.
Correct.
Even if you are a contiguous landowner, certain restrictions.
Fragmentation cannot be permitted.
No, fragmentation cannot be permitted. That you have to obtain permission from the Tahsildar.
That's right.
So what provision? It's a question of cell deed. I am with all beg pardon. The sub-register could not know about things. The Tahsildar could not, officer could not know about it.
Right.
They are allowed to go do wrong.
Right.
It is the 20 years past. They are allowed to do wrong. And we are to suffer. Since a document is present, what is the duty of the DSR? What is the duty of the Tahsildar? Is it not duty of the return the same, refuse the same? So after 20 years, nowadays also this has been happening. The state government is silent. State government officers are doing such things.
All right.
We are sorry, sir.
Right.
Ordinary layman of the interior area,
all right.
Remote area, this.
All right.
I may two distance there. And another aspect I could not got, the Honorable Justice Vishwanath Rao passed a judgment like by submission, single death. It may be referred to. I will give some Monday on that decision. Your Lordship reserve it. I will give a citation for it. Single judge. Division which saying something, two single was saying something. And my contention has been accepted by the single judge, Honorable single judge. Your Lordship reserve, Monday, I will give the Xerox copy of that judgment.
Orders reserved.
Along with supplementary 11. Weekly list item 39.
Weekly list item number 39, my lord, as ordered by this honorable court, I am filing the required documents and a list of the citations to be relied on by me. And the copy of the counter affidavit filed by the respondent number 1 has not been served on me.
It's all right, sir.
And Lordship accordingly may kindly call this matter next week.
No.
Directing them to serve the copy of the counter affidavit.
No, it's all right. It's only a writ appeal. There's no need for counter affidavit.
Lordship, then I will submit, Lordship. May it please, my lord.
Yes.
This appeal is directed against the order passed by the learned single judge in writ petition number 9885 of 2009 in allowing the writ application filed by the respondent number 1. This writ application was filed by the respondent number 1 claiming that his father had purchased some lands by 2 numbers of registered cell deeds. One registered cell deed was of the year 22 February 1965 and another registered cell deed was executed on 16/12/1969. Both the deeds comprised of an area of 4.73 acres of land belonging to the family of the present appellants. And he further claimed in the writ application that during the year 1973, the Tahsildar Dharamgarh found the respondent number 1 purportedly to be in possession of the aforesaid lands, and accordingly, he initiated a suo motu mutation case bearing number 1095 of 1973 and vide order dated 28/1973, which is annexure 1 to the writ application. He allowed the said mutation case. And it was further pleaded by the respondent number 1 that although the mutation was allowed in the year 1973, yet the ROR was not, record of right was never corrected by the Tahsildar Dharamgarh, and after bifurcation of the Tahsil and creation of the new Tahsil at Junagadh, the respondent number 1 is said to have intimated the said fact to the Tahsildar Junagadh, who after going through the records corrected for correction of the record of rights, and thereafter he obtained the
copy of the record of rights via annexer 2 to the writ application. And he further has pleaded in the writ application that after issuance of the ROR to him on an application made by the present present appellant number 1, the Tahsildar cancelled the correction of the ROR by his order marked as Annexure 3, and thereafter he directed him to return the certified copy of the ROR by his order marked as Annexure 4. Thereafter, it is stated that the present petitioner, being aggrieved by the order by the Annexure 4, filed a writ application before this honorable court, which was registered as a writ petition number 4076 of 2009, and this honorable court, while its order dated 10/4/2009, marked as Annexure 5 to the writ application, allowed the writ application, directing him to file an application before the Tahsildar, and if the order in mutation case number 1095 of 1973 had not been varied till that date, then the Tahsildar was directed to pass appropriate order. And accordingly, he made the application, and the learned Tahsildar did not allow the application for correction of the ROR, and rather held that an appeal should be filed against the order passed in the mutation case. And after this order was passed, my lord, the present respondent number 1 filed the second writ application, which I have challenged, the order of which I have challenged in this writ appeal, averring therein that the order passed by the learned Tahsildar is wrong, and he has not complied with the direction issued by this honorable court in the earlier writ. And accordingly, he prayed for quashing of the order by the Annexure 3 and 6 to the said writ application, wherein the Tahsildar had passed the final order. And thereafter, a proceeding for land acquisition was initiated as regards a portion of the land. And after the proceeding for land acquisition was initiated, Lordship, there was a rival claim between the parties regarding the amount of compensation. And after my knowledge of the order passed by this honorable court in the writ application, which has been impugned herein, Lordship, I filed a review application before this before the learned single judge of this honorable court, mentioning therein that by suppressing material facts which have an important bearing on the case, the order has been obtained by perpetrating fraud from this honorable court. And accordingly, I prayed that the order may kindly be recalled and I be given an opportunity to participate in the hearing of the case, as the property belongs to me and is in possession of me and my family. So that review application was dismissed, Lordship, and being aggrieved, I filed 2 number of writ appeals, Lordship, one against the order rejecting the review application, and the second against the final order made in this in the writ application. This honorable court, while directing me not to press the appeal against the application rejecting the review order, Lordship, directed that this appeal will be heard, and accordingly.
Same problem, sir.
Same
problem continues. Yes.
Accordingly, this appeal, the delay has been condoned and the appeal is admitted and has come up for hearing. My humble submission herein is that, Lordship, this is a dispute pertaining to ownership of land and to who has got the title. What has happened, Lordship,
the present appellants belong to scheduled caste category, and this land is a part of the land enjoyed by their father and grandfather in lieu of the services rendered by them for a village office. And after abolition of Village Office Abolition Act in the year 1969, Lordship, the land vested to the government free from all encumbrances, and thereafter in Mafi case number 1 of 1970, the record of which had been called for by this honorable court in the writ application, Lordship, and is available, the land was settled with the father of the present appellants in the year 1973, and which fact has been suppressed by the present respondent number 1 in the writ application, Lordship. And thus by perpetrating fraud, the order had been obtained. Apart from this, Lordship, regarding the same land, the present the father of the present respondent number 1 had filed 2 numbers of mutation cases in the year 2006, and both those mutation cases were dropped by the Tahsildar regarding the same lands, and that fact too was suppressed. And moreover, Lordship, this man, the respondent number 1's family, is a big family, a rich family, and their lands was subjected to a sealing proceeding. And in the sealing proceeding, after showing their lands, some land have vested to the government, and these respondent number 1's family did not show these lands in the sealing proceeding. And accordingly, Lordship, all these had been obtained by perpetrating fraud, and accordingly, I have relied on the decisions. Your Lordship may kindly see the decisions today relied on by me. The first one is AIR 1985 Supreme Court at page 167, the case of Prabodh Verma and others versus State of UP and others, wherein at paras 28 and 50, Lordship may kindly see para 50 at page 189. Para 50, subpara 1. A High Court ought not to hear and dispose of a writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, or at least some of them before it as respondents in a representative capacity, if their number is too large to join them as respondents individually, and if the petitioners refuse to so join them, the High Court ought to dismiss the petition for non-joinder of necessary parties. Wherein, here in the instant case, Lordship, it is the case of the respondent number 1 that on my application, the order was varied, and the order by the annexure 3 to the writ application was passed by the collector, the Tahsildar, Lordship, in the mutation proceeding. Why the Tahsildar passed the said order in the mutation proceeding? Because after issuance of the ROR in the name of the present respondent number 1, I appeared before the learned Tahsildar and I stated to the Tahsildar that these lands are settled in my favor in a proceeding under the State Abolition Act, and by suppressing this, the mutation proceeding has been filed and the land is being possessed by me. I am paying land revenue in respect of the land, and without issuing any notice to me, this order has been obtained.
and thereafter the Tahsildar cancelled it. So it was incumbent on the part of the respondent number 1 to have implemented me as a party in the writ application. Then I could have my say. And this is what I brought before the Honorable Single Judge of this Honorable Court in filing the review petition that I should be given a chance of hearing in the writ application. Then the second decision which I have relied on, Lordship, is again regarding necessary party. This is a decision of this Honorable Court in the case of Ram Kumar Agrawala and another versus State of Orissa and others, AIR 1965 Orissa at page 125, wherein in para 1 of the application, the then Honorable Chief Justice of this Honorable Court, Chief Justice Narasimham, he has observed there can be no question of the court desiring certain parties to be included as parties, and it is the duty of the petitioner seeking relief before this court to include all the necessary parties.
All right, sir. All right.
Lordship.
Lordship, I am.
Lord, I am appealing. Lord, on behalf of Mr. Thal, your Lordship will permit me to address your Lordship.
Yes, yes.
Then,
Lord,
1 minute, sir. Let us hear Mr. Rathur. Yes.
Then,
1 minute, sir.
Lordship.
Yes.
Now, Lord, whatever is submitted with your Lordship, if I have understood it correctly, all that matter relates to mutation of a particular property.
No, at a very simple level, sir. If you read the impugned order, only 2 parties have been heard, state and the petitioner.
Correct, Lord. Lord, on that, my submission, that my straightway, Lord, my answer to your Lordship would be, my Lord.
Yes.
Lordship will see this particular property, my Lord, little one, 2 line fact, and thereafter I'll straightway address your Lordship on that question of non-imputation of party. My Lord, 65, 69, these properties were purchased. Now, these are mutated in the year 1973. For long 35 years, these legal heirs of my vendors were not in picture. They were never challenging my mutation nor ROR. 35 years after, when the question of acquisition comes, they straightway come forward before the Tahsildar and challenge my ROR, saying that this recording is incorrect 35 years after. Now today, that recalling of mutation, it has a checkered career. It came and went back. Ultimately, I challenged the Tahsildar's order before this Honorable Court. But admitted fact remains that he has not been implemented as a party.
So how will they even do a right thing? You have to do it in the right way, sir. A right thing cannot be done in the wrong way.
Lord, I can tell that. Lord, today, impugned order has been passed without implementing him as a party.
Right, so again, you're just, this become a cat and mouse game then.
That's right. But today, he has not been heard. That is what his allegation is.
At least one forum, all of you must be heard together.
That's correct, Lord. I cannot dispute that proposition of fact, Lord, because he has not been implemented as a party. But I have a submission before your Lordship. If your Lordship kindly consider that. That submission is, if the person is not a party, what is the remedy available to him? Lord, that is 1963 Supreme Court 1909. Paragraph 4. If your Lordship would kindly see that judgment, it's a very small paragraph. 63 Supreme Court 1909 clearly says, if an order has been passed by a writ court without implementing a person as a necessary party, then the person aggrieved has to file an application for rehearing of that matter.
He filed a review, sir. Review got dismissed.
So review, since he was not a party, review was not maintainable, my lord. Your Lordship knows that.
No.
Review is not
now being hyper technical. Yes.
That's correct.
What else can he do, sir? What else can he do?
Now I am coming, my lord. What else he can do, my lord? He has challenged the order. My lord, I am closing one after other points before your Lordship. My lord, what can be his probabilities? He could have filed application on Article 226 for rehearing. Today, he is not taking recourse of that. Now, what he is challenging is filed a review application. Review got dismissed. Filed a writ appeal against that. Now that is disposed of. Secondly, what he has done is he has filed a writ appeal challenging the Honorable Single Judge's order. Now, he was not a party there. 71 Supreme Court 474. He was supposed to take a leave from your Lordship to file an appeal. That also he has not done. Now, he is challenging the order before your Lordship without taking leave. Though he was not a party.
All this end of the day, the impugned order has been passed without hearing him. So
that's correct, ma'am. That's correct.
We go all round in circles and come back to the same point. The better thing is to send it back to the single judge. We'll have a time-bound disposal.
As your Lordship proposed.
All right. We'll pass that order. The matter will now be listed. The impugned orders are set aside.
Your Lordship may kindly indicate that your Lordship has not expressed any opinion on merits.
Obviously not. Obviously not.
Lordship, some documents will file.
All that you file now before the single judge, sir. To be listed before this learned single judge for direction on 18th April 2022, when all parties will appear. They will cooperate in ensuring disposal of the writ petition within a period of 6 months thereafter. Till then, both parties will maintain status quo.
Well, fair enough, because at least he will not have any further grievance of making allegation that I was not part.
Right.
Weekly list item 40. Weekly list item number 40.
My lord, this is a case under I have come after it was decided under section 25 of the Orissa Hindu Religious Endowment Act, and I was asked to vacate the land which I have been occupying, and I am a Sebak, and I also claim to be hereditary Sebak, and I have also filed a case under section 41. Section 41 of the OHRE Act, Orissa Hindu Religious Endowments Act, says that it will decide the nature and character of the case, DT, and the properties. So when a case under section 41 has not been decided and the case land has not been declared as public religious endowment, this case under section 25 would not lie. So the similar case, your lordship had passed last week.
Similar case, your lordship has disposed of section 25, 3 remedies available to file a suit against that order of eviction. Suit is the proper remedy under section 25, subclause 3. My learned friend knows it. So he has to, and recently one writ petition was withdrawn with a liberty to file a suit under section 25.
So you can withdraw this, sir, with liberty to file a suit. Counsel of the petitioner seeks leave to withdraw this petition with liberty to avail of the remedy available to the petitioner under section 25 bracket 3 of the Orissa Hindu Religious and Endowments Act. Disposed of is withdrawn with liberty spread.
List item 41.
My lord, the petitioner claimed compensation due to death of one Dusasan Behera, who was a under trial prisoner and was in jail custody at Fulwani on 27/2007 due to non-taking prompt and appropriate action on rendering medical aid in hospital to the deceased in due time, which caused gross negligence on the part of the jail authorities as well as the official authorities. The fact is like this, Miller. May I audible, Miller?
Yes, please.
Petitions number 1 is a husband, wife, and petition number 2 to 5 are the children. Petitioner number 1, husband, was arrested on and forwarded to the jail custody on 6/9/2007 for the offence under section 27(3) of the Forest Act and 21 of the TT rules. On the allegation that on taking a piece of size T code.
So the only one difficulty you will have, sir.
Yes.
These are disputed questions of fact because opposite party number 3 has filed an affidavit. Are you aware of that, sir?
Yes.
Are you aware that opposite party number 3 has filed an affidavit?
No, he has not given any affidavit.
You are arguing a petition without seeing any counter affidavit. Are you aware in the last 10 years, 12 years, 2 counter affidavits have been filed? Are you aware of that, sir?
That I have received, my lord.
Can you come to the counter affidavit filed by opposite party number 3?
Yes, my lord.
Can you come to para 8, sir?
Yes, my lord.
Just read para 8.
That in reply to the averments made in paragraph 6 of the writ petition, it is humbly stated that on the same day, on 6/9/2007, the deceased was forwarded to court and remanded to the jail.
No. Which para 8 are you reading? This is the affidavit of Mr. Birabar Nayak, Superintendent District Jail, Pulwani.
There are two affidavits. Probably my learned senior is reading the other affidavit.
Yes, I'm reading out. That in reply to the averments made in paragraph 15 of the writ petition, it is humbly stated that on 27/10/2007, while the deceased UTP was jail custody, all of a sudden, at about 9:20 a.m., he was affected by fits and became unconscious, for which he had shifted to the district headquarters hospital, Fulbani, then and there, as per the advice of the jail medical officer, district jail, Fulbani, for specialized treatment, though through guarding staff of the jail, he was admitted at the district headquarters hospital by bedhead ticket number 60 as indoor patient, bearing number such and such.
Sir, are you disputing this?
Yes, my lord. I am. My kindly see the annexure 2, my lord.
1 minute, sir. 1 minute. Are you disputing this?
Yes.
Have you filed a rejoinder?
No, I have not filed any rejoinder.
So why have you not filed any rejoinder for how many years now? This was filed when?
No, I am disputing not the fact. The facts is like
this was filed on 30th July 2010.
Yes, my lord. They have.
We are in 2022, sir.
The law point, the factual aspects I want to show, my lord. That is.
We are only on factual aspect now, sir. We are not on law points now.
Yes, I am not.
What you have read out now is factual aspect. We are asking you about that factual aspect.
Yes, my lord.
Are you disputing what you have said?
I want to draw your kind attention to my annexure 2, my lord. The medical report. That I will get the answer, my lord.
What answer you will get, I don't know. Yes.
My lord,
in writ petition seeking compensation for custodial death.
Yes, my lord.
Unless there is an objective inquiry report, it is not possible for a writ court to adjudicate disputed questions of fact. Correct? That's the settled law.
Yes, my lord. It is crystal clear in annexure 2, my lord. That medical report. He has received the deceased, that UTP, on dead. They have taken delay to admit in hospital. My contention is that they have taken all steps, but they have reached in hospital in late. That annexure 2 has page 26, my lord.
This is the same annexure 2 they are explaining, sir.
My lord?
This is the same annexure 2 which they have explained now in the paragraph that you read.
That is, but I am giving the actual fact. They have stating other things.
You may assert that this is actual fact. They have asserted something to the contrary. Who will dispute? Who will determine this disputed question of fact?
That is the documents. The documents I have obtained from the RTI Act of the medical, that is itself clear that they have received it on a dead body.
Where do you get that?
My lord,
Where do you get that? Where do you get that?
That page 26 annexure 2, written as in Odia, Mrutyura Karan, autopsy received, autopsy required, and UTP received dead.
Where is it?
At the right side of the angle, my lord. Right side angle. Autopsy required as UTP received dead at 10 a.m. And in left side, the pulse not recordable, the BP not recordable,
What is HS?
My lord,
What is HS?
age of the deceased.
No, no, no.
Outdoor examination, the abbreviation HS stands for what? Degree of days.
And in annexure 3 also the written clearly received dead at a medicine ward.
Just see, reply to para 18, that will tell us.
Para 18 of the counter, my lord.
No, no, the reply to para 18 of the writ petition.
Yes, madam. I am reading out. That in reply to the averments made in paragraph 18 of the writ petition, it is humbly stated that as per the advice of the medicine specialist, all the pathological tests would have been done because there was no ample scope for the same due to sudden death of UT prisoner in Indore hospital while
This report of inquiry is there.
Report of inquiry is annexure, my lord. That is L by 3 in counter they have given at page 24.
It's not readable at all. All right, we'll continue after lunch.
Yes, ma'am.
Excuse me, Lord. Item 28. Lord, I am ready, my Lord. It has been dismissed due to my non-appearance.
We'll take it up. You wait.
Okay.
28. Matter fixed for 2 p.m. Supplementary list. Item number 36.
Lordship may kindly see the affidavit that
Item number 36. Supplementary.
I have
My
filed
Lord.
an-
Mr. Raut, you will have to wait. We are now on item 36.
My Lord, my Lord. Sorry. Yes, my Lord. An affidavit has been filed on 16th December 2021. That is by the Undersecretary to Government Fisheries Department. That is relating to all the IAs filed by my learned friends from different districts and the status of the land, status of their land till that date. So Lordship may kindly look to that, and I have served a copy to Mr. Agarwal, amicus. This affidavit was not placed on the last date.
This affidavit filed on behalf of Collector Ganjam.
No, my lord. Abhiram Nayak, Undersecretary to Government, Fisheries and Animal Resources Department.
Aviram Naik, correct.
That your lordship may.
Flag 115.
Yes. The annexures starting from page 12. All the IAs are dealt with and their status of the land I have indicated in a separate column. And so also in the body of the affidavit, we have mentioned at page 6, para 13, that 16 intervention applications have been filed by 109 interveners, and on perusal of such application and as per the detailed report received from the Director of Fisheries Orissa, the following position emerges. A, B, I have given all this, C, D, E, and I think the case of all my learned friends appearing for the interveners covering this till that date.
So many of them are not permitted.
My Lord, the copy of that petition has not been served on.
Not petition, sir, affidavit.
Affidavit has not been served.
We have not received an affidavit, ma'am.
We have not received my, they have not served. Your officer directed me to give my number and email. I have given my email address and number, but that has not been served on me. I have provided to Mr. Mahathi, but that copy has not been provided. Yes, into my email address and also the telephone number.
The number which our government advocate told we have submitted, and the government advocate assured us that to supply us the counter
copy of this copy of this.
No. To some advocates we have provided the copies.
We have not received Lordship. We have not also received the.
All right. Many of the advocates for interveners state that they have not received a copy of the affidavit dated 16 December 2021, filed by Aviram Nayak, Under Secretary to the Government, Fisheries and Animal Resources Development Department.
May I frame one thing to my lord? I will file 15 copies of this affidavit before the judicial registered judicial. They may take the copy because it is difficult. Will pass an order. We will submit 15 copies of this affidavit before the registered
How many
judicial.
intervention applications are there?
16.
All right. Mr. Mahanti states copy of the said affidavit along 15 copies of the said affidavit along with the annexures.
20 copies I will give.
20 copies of the said affidavit along with the annexures will be placed with the Deputy Registrar Judiciary.
Yes, ma'am.
Within 3 days.
Yes, ma'am.
It will be up to the counsel for the interveners to collect a copy thereof from the DR Judiciary before the next date. Responses, if any, there to be also be filed before the next date.
Yes, ma'am.
What else is on the main matter?
Yes, my lord, your lordship had directed the collectors to file the latest satellite imagery and which has been superimposed with the cadastral maps. Like
Intervention application, then
those intervention application may be disposed of. Yes. Concerned. This is within the Kendrapada district. Collector is sitting here.
Yes, sir.
Mute. Please unmute, Mr. Collector. Rutraj.
You are not audible.
So far as Mahakalpada is concerned, that is one hamlet in Kendrapada district. It is already ready. Today we are signing, the Tahsildar will sign it and it is ready. I can show it to my learned friend also.
All right.
And I will provide a copy.
The satellite imagery in regard to Mahakalpada, which is within Tahsil, which is within Kendrapada, is also ready, he says.
Other two tahsils are there, my lord. One is Rajnagar, another is Rajkanika.
Yes. Others are there. My lawn client belongs to Rajnagar.
Rajnagar and Rajkanika. Both.
As regards the other two tehsils of Rajnagar and Rajkanika.
Yes, my lord.
The maps be provided within the next 2 weeks.
Yes.
The amicus curiae is permitted to inspect all of these maps.
I have served a copy to amicus. So far as Mahakalpada is concerned, I have already served.
While the copy of the map of Mahakalpada has been served on the amicus curiae, in relation to the other satellite imagery maps, he is permitted to inspect them in the office of Mr. D.K. Manthe.
Yes. Another Mr. Dalai, I think he is not present. Last time he has submitted regarding one issue. I have given a counter to that particular submission, and that is the counter dated 2nd March 2022.
Has that been removed, sir?
Yes, that is there.
All right. Mr. Manthe also submits
that is called in Krishna Prasad Tahsil.
Yeah, an affidavit regarding removal of illegal. These are hatcheries.
No hatcheries. It's not hatcheries.
Earthen gheries. Earthen.
These are prawn ponds, Lordship, not hatchery, Lordship. Prawn
Yes.
ponds.
All right. In the Krishna Prasad Tehsil. All right. Which is the other district? I think Puri and Khurda is ready. The satellite imagery maps.
The Krishna Prasad is Khurda.
No, satellite imagery maps.
Puri and Khurda.
When will that be ready? Puri, Khurda and Ganjam. Ganjam is this one.
Yes.
This is Ganjam. What you have?
No, this is Kendrapada. This is Kendrapada.
Oh.
We will show it.
The satellite imagery maps in respect of the districts at Puri, Khurda and Ganjam.
Next.
Provided
by the next date, we will file it.
By the next date. All right. I think much is happening, no? What is happening on the ground?
Yes, Your Lordship. Even I have been forwarding them. There's a problem of re-emergence of the gheris after eviction. I will devise some method now how we have to control that, because they are removing it and again the villagers are reconstructing.
In some cases in Puri district, what my learned friend is saying, these are happening, and immediately again those are removed.
Because this cannot go on from year to year.
Yes, the collector Puri is here, Mr. Samarth Verma.
Good afternoon, sir.
Yes.
Sir, as rightly pointed out, sir, we have removed all the gheris, sir, but the problem of resurgence is happening, sir. But our tehsildars and patrolling teams have ensured that more or less, sir, resurgence has been kept to a minimum, sir. And wherever resurgence is happening, sir, we are taking stringent action, sir.
No, but why is this happening? Lack of awareness, lack of enforcement?
Sir, actually,
because last time when we spoke, you said you will keep the platoons in that same area after removal for some time at least, right?
Yes, sir. Yes, sir. Wherever we are removing, sir, regularly our patrolling teams are going there, sir. And by and large, sir, almost most of the cases, sir, resurgence is not happening, sir. There are attempts to do it again, sir, but that also has been stopped in most of the cases, sir.
No. What are the other mechanisms you are using? Because in some areas, police is using drones kind of a thing to keep a constant surveillance. Are you using those kind of techniques?
Basically, sir, local intelligence, sir. We get information, the tehsildar gets information, I get information through various communication channels, sir, that in particular area, the gheri has resurged, sir. There we send our police, sir, and wherever we suo motu have done the eviction, by our own means, sir, we do a regular watch over those areas.
No, I think you may have to use something else to keep a constant monitor.
Sir, basically, sir, ORSAC, sir, the Orissa Remote Sensing Agency, sir, they have provided us almost 22 satellite imagery of 22 revenue villages, sir, showing the areas that have been evicted recently, sir, but as on 31st of December, sir. So we will keep getting those maps in a period of, say, 2 months or 3 months, sir. That will give us an idea of how much resurgence has happened over the entire area through satellites.
You say, Mr.
Sir, ORSAC has submitted the maps, sir, and we have also submitted to the AG officer. The ORSAC images, sir, the tehsildar has gone there with the hard copy as well today, sir.
You say the learned amicus curiae has pointed out that in Puri district, the problem of re-emergence of gheris, illegal prawn gheris, soon after their removal, continues. Stop the collector Puri, who participated in virtual mode, admitted that this problem persists, but states that they are receiving regular inputs in the form of satellite imagery maps from the Orissa Remote Sensing Agency, and that the surveillance operations to ensure non-re-emergence of the illegal prawn gheris is being stepped up. Stubby is hopeful of keeping the problem under control. Paragraph. On the next date, the court will be informed of the actual steps taken to control the problem. What about the other districts, sir?
The other collectors
In Ganjam also there was a re-encroachment which I recently I forwarded the photographs to the collector.
Is the collector Ganjam here?
Yes.
Sir, good afternoon.
Yes.
Sir, we received photograph also, and proactively we are taking action also. The photos sent by Amicus Curiae, sir, some photographs from Puri district and some 2 photographs from our Palur hill side, Palur canal side. So immediately we removed it. It's that wooden stick they are using, sir, and within 2-3 hours they are preparing this type of structure. But continuously we are watching, though our scale of this giri is very low, but still we are very keeping vigilance, and we will ensure further encroachment.
Are you booking cases, sir? Are you registering FIRs?
Yes, sir. Yes, sir. Already we have registered FIRs, and it's in continuation. We are.
No, with this photo, when you removed, what did you register an FIR when he sent you the photo and you removed it?
No, sir. Nobody is coming forward. The identification.
No, you can yourself be the complainant. Why
Yes,
should
sir.
anyone
Yes,
come
sir.
forward?
No, sir. Against whom? So we have filed FIR, sir. Sir.
The collector Ganjam states that after receiving photographs of 2 illegal prawn gheris in Ganjam district from the Amicus Curiae, prompt action was taken to remove them. He states that FIRs in respect of both such instances have been filed. Stop. What about Khurda?
My lord, so far as this Ganjam district is concerned, your lordship may note that one affidavit is filed by the Tahsildar Ganjam on 13th January 2022, indicating the position.
All right.
So far as Palur Canal is concerned.
All right.
That may be taken up.
What about Khurda?
Sir, namaskar, sir.
Yes.
Sir, we have already submitted the cadastral map and the superimposed details to the AG officer much earlier, and
we have the cadastral map.
So in that earlier thing, you include Khurda as well. Cadastral maps of Kendrapada, then you say Khurda. Yes.
Sir, our whatever information that the Amicus Curiae has given in the month of December, sir, that we had already demolished. And in the month of January and February also, sir, there was no reappearance of the net gheri, sir. The constant, we have 2 boats, sir, from the Chilika and Tangi side, which are moving a lot in thrice a week. So that is why we are able to monitor it. And second thing is, sir, as 200 meters is a no-go zone for any of the gheris, either it is aquaculture or a fishing or is a prawn gheri, sir. We have demolished around 300 acres. And we have an action plan, sir. Within the coming 4 months, we will demolish all the earthen gheris also, sir.
The collector Khurda states that the problem of re-emergence of illegal prawn gheris is under complete control. And concerted action is taken to patrol the area to ensure that no illegal prawn gheris, new illegal prawn gheris emerge. He's confident that in the next 3 months, all the illegal prawn gheris that exist will be removed.
My lord, in
A month-wise status of removal of illegal prawn gheris be filed before the court. And the list of FIRs registered in respect of each such instance also be provided.
My lord, the Tahsildar Tangi has filed an affidavit on 13th January 2022. The list of FIRs have been registered and that is on in the record.
Tahsildar?
Sir,
Tangi. That
Tangi,
is
sir. Sir, within the Khurda district, sir. Sir, we require 4 months, sir. We require, sir, not sir, 3 months, 4 months.
Say 4 months, all right. But you give us a monthly status report, sir.
Yes, sir, we give, sir. We give, sir, almost in every month wise also. Sir.
Is the Kendrapada collector now audible?
Yes, sir. I hope I am audible, sir. Yes, sir. Sir, for Mahakalpada, sir, there were 15 patches for which we had got satellite imagery, sir. We had given the superimposed map of cadastral map along with the high tide line demarcated by the forest and tehsil officials jointly, sir. We have filed it for the AG officer. So as per the joint visit report, sir, there are 15 patches and the land particulars of and land use pattern of all the patches have also been given, sir. Sir, as per the report of the field officials, in many of the patches, the pisciculture which is practiced is traditional, sir. So that may require further elaboration from technical team, sir. That they have been practicing pisciculture for long. It's as such, it's not shrimp or prawn gheri in those particular 15 patches, sir.
No,
The
first of
maps
all,
we have supplied,
no,
sir.
no.
So,
First of all, tell us this Rajnagar and Rajkanika. You've not given us satellite imagery maps yet.
sir, satellite, sir, we have received for Mahakalpada only, sir. So we have given the superimposed map for
No, what about the other two tehsils?
Rajnagar, other two tehsils, NSCM, sir, once we get, sir, we'll supply, sir, with superimposed cadastral. We have got for Mahakalpada only, sir. In December itself, we had
No, why is
given
that
the
getting
superimposed.
delayed? Why is the map for the other two tehsils getting delayed?
Sir, we are pursuing, sir. Sir, we hope to get it in.
And how many have you removed, sir? How many illegal prawn curries have you removed in the last 2 months?
My lord, I have given an affidavit today that I have served copy on amicus also. We are going to file it. There are, in the meanwhile, we have removed 24 illegal prawn gharis and number of illegal prawn gharis to be evicted is 89.
An affidavit has been filed today.
My lord, this is the affidavit. Lordship, I will file it in email. Lordship can refer it. I will file it.
An affidavit of the Deputy Collector, Revenue Collectorate, Kendrapada, has been handed over. Interior states that
that is the
24 prawn gharis, illegal prawn gharis have been demolished between 20th December 2021 to 17th February 2022. A balance area of 92.28 acres of illegal prawn gharis are still to be demolished. What about the registering of criminal cases here?
I think there is no disclosure so far as this matter is concerned.
The Deputy Collector Kendrapada, Deputy Collector Bracket Revenue Kendrapada is directed to place before the court the list of FIRs registered in respect of the demolition of the prawn gharis and filed further status report on the action taken during the month of March from 17 February 2022 till the end of March by the next date. When should we have this? We'll have it on 4th April.
4th April.
Yes, Your Lordship.
Obliged.
Okay, list on 4th April.
Flag number 130.
Yeah, so obviously, so interim orders.
My lord, your lordship, flag number 130, your lordship may consider there is an interim order which may need some variance because there the state has filed a counter that in the net gheris are there where the petitioner has obtained a stay. So those are totally impermissible because that patch of land is being prevented from getting evicted, my lord.
What is that? Which is it?
Flag 130, your lordship.
That is IA 18800.
188.
I filed objection. Have you got that objection?
Yes.
Okay.
At page 8 of that flag, the last paragraph.
Tichini.
Yes,
Villages of Tichini were not.
That is there. That is why we have filed the objection that the interim order needs to be vacated.
In
Because
this
we have
IE.
never allowed him any lease or any permission to operate that. That is the affidavit of collector on behalf of the collector. The collector himself has shown the affidavit. That is the objection filed in IA number 18800 of 2021.
Have you served a copy of this?
Yes, that lawyer who is the lawyer appearing.
I'm appearing for this particular IA minutes.
Yes.
18800.
18800. It's at flag 117.
So they filed these objections. Have you got
not
them?
received any copies of the.
Okay, I'm
All
getting
right. Who's permit to respond to it by the next date. All right. List on 4th.
The order will continue, my lord.
Yes, please. Yeah.
One digression. One digression. I was just hearing your lordships before lunch. Just Mr. Nandi's case. Lordship wanted to know what was HS. So in the context of BP not recorded, pulse not recorded, HS may be heart sound.
Oh, heart sound.
Yeah. Maybe so. I'm sorry for
Right. No, could be.
Because
You're
in context
absolutely
of
right.
pulse and BP, it is heart.
Correct. Thank you.
Welcome.
Supplementary list item number 39. Supplementary item 39. WPC 37468 of 2021.
My lord, my lord, item 39. May I submit, my lord?
Yes.
My lord, in PUDRT matter.
Yes, please.
Yes, already I filed the affidavit. My lordship may not receive this decision. So morning about 11 o'clock we will send it. But facts remain that already PUDRT has been appointed. We have, the ministry has offered the joining letter to them, and most probably they will join very shortly.
No. What about Cuttack?
Cuttack also appointment letter has been issued, my lord.
When will they join? You give us a date when they will join.
Yes, my lord. I'll can you let me pass over and I can.
Yes, we'll pass over. And make sure the affidavit comes. Mr. Raut, you wait.
Weekly list item number 41.
Yes, my lord. They have filed the report at Annexure LE, my lord. That is at page 24 of the counter.
Sir, how did you not get this matter listed for 12 years?
That is the fault of the machinery, my lord.
No. I have been Chief Justice here for 1 year, sir. Don't blame the machinery.
My lord, not this case. So many cases are there pending since long.
Even so do you know how much mentioning happens?
Yes, my lord.
Have you tried mentioning this matter, sir?
Mentioning from your lordships come that thereafter mentioning and allowed and something else.
Did you try mentioning this?
Paucity of the judges also it has been not listed.
You have not made a single effort, sir. It's unfortunate.
That's true. Then
even today it is being taken up because we have listed it.
Yes, madam.
how does one verify these facts, sir? The death take place?
That took place on 27/10/2007.
So we are talking of something that happened 14 years ago.
Yes, ma'am. That, my lord, kindly, when on the day of custody, his health was checked up. There is no infirmity. That is, I have filed, that is annexure. Annexure 4, my lord. No, their allegation is that epilepsy is there, fits and epilepsy. But at the time of 6/9/2007, there is no such allegation. Thereafter, on 10th, at page and the report itself says he has filed in L3 at page 24. The cause of death not known. That is also, the inquest report is also stats like this. Inquest report at page 18 of the counter. At the last column, all are Odia, but in last column it is written in English. The cause of death of the deceased of Dushasan Behera not known. That is also according to a report he has filed. He has taken, as per that, he has taken Upama at breakfast at 8:45 p.m. 45 a.m. But
as per that report, Mr. Nandi, 8:45 a.m. That attack took place. 9 a.m. He was administered that injection. 10 a.m. he was taken. 10 a.m. he was taken to the district headquarters hospital.
Yes, ma'am. I am reading of that.
Prompt action.
Yes, but the medical report, the postmortem report says that there is the entire abdomen is empty, but he has taken Upama at 8:45 p.m. as per their report.
No, but how does all this add up, sir? You're trying to say this is negligence, correct?
Negligence because they have not, they have stated everything, my lord, right, parrot like this, that I have taken to hospital.
What is your case? What is your case?
My case is that they have, due to their negligence, he has not.
No, you're giving a conclusion. What is your case? What happened that morning? According to you, what happened? Don't give us conclusion. Give us a narration according to you what happened.
It was not known to us, my lord. Exactly, I came to know.
Sir, if you don't know, you have to find out. You can't simply allege, right?
No, my lord.
Simply
Because
make an allegation.
He was in the jail custody. It was not known to everyone, anyone, my lord.
Do you have any different version of any inmate in the jail?
Inmate, they have said that due to epilepsy and fits.
Mr. Nandi, are you understanding the question or you're not understanding the question?
Yeah. Inmate says that due to unconscious.
Which inmate?
The 5 inmates in ward number 5 of the deceased. That report itself says.
Where is that?
At page 24, madam.
Page
of the counter. It is written in page 25. From the statements, it revealed that at 6, 7, 8, after 9 lines.
No, 1 minute. Then he treated and administered injection at 9:10 a.m. in the jail hospital.
Yes, madam. That is there.
And then he was taken to the district headquarters.
My
hospital.
contention is that.
So what do you think should have happened? What according to you should have happened?
Madam, why I say I have marked that they have taken Upama at 8:40 p.m. But the postmortem reports of the abdomen says that it is empty. But
I don't understand.
They have administered the injection in the empty stomach, my lord. They have how they can know that it is epilepsy.
But have you taken any independent view of any doctor that administering that particular injection, empty stomach, that will lead to some seriousness or may become fatal?
Where does it say stomach is empty?
It's saying postmortem report.
Where is
Postmortem.
That is Annexure 7 at page 33.
Death was resolved, my lord. Awaiting the, my lord, special report, my lord. Lordship may kindly see that report.
Here.
That is also there, page 36. Annexure P by 3.
Abdomen. Where does it say the stomach is empty?
Sorry, madam.
Where does it say stomach is empty?
Yes, ma'am. And at page 33, were 10 bladder empty. That is column I for abdomen. That is empty. Right side, second column.
No, bladder is different, sir. No. Stomach and its contents. You are completely mistaken.
Yes.
Contains about 150. You are completely mistaken on that, sir. Stomach and stomach. I don't think there's anything.
Yes, ma'am.
And at this, I'm for the opposite party, my lord, in this case. My lord, I'm for the opposite time. By order dated 21/4/2014, I have also circulated copies of that, my lord.
You have to repeat yourself.
Lordship, this issue has already been resolved by this honorable court by in WPC number 16836 of 2009, my lord. By order dated 21/4/2014. I have circulated the orders, my lord.
Where is that?
A similar set of facts.
In due to.
Lordship, you see the last paragraph. It is in the case of the petitioner itself. Same set of facts.
What do you say? You are for the petitioner?
Yes.
It's covered.
My learned friend is submitting one part of the case. And there are...
It is the only question that remains
No,
to be
that
decided.
was not the only question.
Well,
There are two questions involved in the case. The point is that, my lord, just briefly I am stating before I take your lordships to the order, impugned before your lordships. My lord, at the contract demand of 100 megawatt, the power supply had been obtained by the opposite party. It is a large scale industry that they had obtained. And my lord, whatever they may consume, but as per the OERC regulations, Distribution and Condition of Supply Code, they have to pay the minimum of the charges up to the contract demand. Whatever they may, that is the as per the agreement. Well, for a certain period, that is for the month of March, April, May, and June, SLDC, State Load Dispatch Center, well, they relayed the supply and they had restricted the power supply at a first instance to 30 megawatt and then at the 50 megawatt. So for that period, the consumer, the opposite party, they also requested to the WESCO. Then WESCO, now it is your lordship, I will be requesting, paying your lordship, that should be also TPWODL. It has been substituted. They requested that as per the agreement, under the supply code, I am bound to take the load at that 100 megawatt. However, that was not accepted, and the petitioner also said that since you have taken this load, so you are bound by the agreement, and that is as per the regulation, you have to pay at that rate. At whatever you may consume, that rate. And number two, it is not a statutory restriction in view of section 85(3). So for that, order is placed before your lordship saying that it is a cover order, 85(3). But number 2 point is that there has been overdrawal of the power. If there will be overdrawal of the power, that is not for the restricted period, that is for July 9. In the month of July 9, for that overdrawal penalty was demanded, charge. And my lord, while the GRF has decided, instead of deciding in the context of the tariff order, because as per the tariff order, there will be charges. The GRF has taken into consideration of the
Come
so
to para
far
2, sir. Come to the page 161, para 2.
last. My lord, yes, my lord.
Please read para 2 regarding the overdrawal.
Regarding the overdrawal penalty for the month of July 2009, the forum is of the view that charging of overdrawal penalty Lordship kindly see in this regard. Your Lordship kindly see page 59, 159.
Yes.
Your Lordship kindly find that. My Lord, para starting just after the first 3 lines. Besides the above, the consumer has applied for relief in connection with the overdrawal penalty imposed by the opposite party in their bill for the month of July 2009. The complainant has exceeded its CD in the month of July 2009 during peak hour to the extent of 27,368 kVA and to the extent of to 21,464 kVA during off-peak hour. The complainant stated that it has been charged overall penalty twice during peak hour and off-peak hour. The learned counsel for the opposite party pleaded that the similar type of case is pending before the Honorable High Court, Orissa, and hence the matter should not be considered at this stage. The forum produced the detailed tariff order as well as OERC Distribution Condition Supply Code 2004 and abstract of the RST order for 99-2000. My lord, on that basis they have passed the order, whereas your lordship will file in the complaint as well as in the counter 457, 458 of the paragraph of the tariff order of 2000. My lord, here it will be applicable. So far, April 9 up to March, April, May, that is there, that will be for 9-10 tariff year. And they have considered this thing. I will draw your lordship's attention to that.
I have not understood anything that you have said.
Pardon?
I have not understood anything of what you have said.
My lord, I have read the brief, my lord, half of the day yesterday and also in the morning. But with much difficulty, I could
So
not.
deemed, you are deemed to have understood, therefore. All right. If you cannot further enlighten us, we will say we are deemed to have understood.
My lord, what I beg to
Because learned senior counsel has read the brief last night and this morning, the court is deemed to have understood.
No, that I am not saying. I am saying, my lord, this is a technical matter.
When the court says if you have not understood, you should not say, sir, I have read it last night.
No. What I beg to submit that, my lord, with much difficulty, I could understand it. My lord, with this short time, my lord, I may not be able to make your lordship to understand. That is why I am trying to make your lordship to understand. My lord, lordship kindly see the complaint petition, page 23. I may be excused, your lordship, or misunderstood me. Not that, my lord, I have not. Lordship, kindly see page 23. Annexure 1, that is the complaint. Your lordship, kindly see in the matter of, second page, third, in the matter of an application challenging illegal improper demand of overdraft penalty for the month of July 2009 during the being contrary to paragraph 457 and 458 of the retail supply tariff order dated 23/2009 for the year 2009-10. But we also reiterate the same thing, and your lordship will find that is page 39. Page 39. This is not been considered by the GRF. The lordship kindly see page 39. What I beg to submit, the GRF ought to have considered the tariff order of that relevant period, that is of 2009-10. So 457, 458 have been quoted there. Page 39. Your lordship kindly see overdraft. I am reading that 457. Overdraft during off-peak hours, as per the existing tariff provisions, there is no penalty for overdraft during off-peak hours up to 120% of the contract demand. The Commission has decided that the existing facility now available to the consumers will continue in the interest of the state hours other than off-peak hours. Such excess demand is liable for a penalty. That we have done. That has not been considered by the GRF. There is escape this aspect.
Yes, Mr. Monty.
And will
Lordship, see page 14
is there.
Lordship, see
So
page
for the
14.
SLDC, which has restricted the power, we are saying it should have been by the OERC.
No. We are not entertaining that
Your
issue
Lordship,
at all.
your Lordship may see page 40, your Lordship. Your Lordship may see page 40. What we are saying is, now there Voisco has, if they are admitting that this should have been adopted, then your Lordship may see page 40. Column serial number 5, your Lordship.
Yes.
They have charged me 97,66,400, whereas as per the tariff order, it should have been 54,74,600, and that is what the GRF has done. They have only applying this tariff order, They have only told the petitioner to refund the excess refund.
So overdrawal can only happen during off-peak hours, correct?
Lordship.
It cannot happen during peak hours.
Lordship.
But there is no reasoning, no consideration regarding that in the GR.
That's all right. You say two issues have been raised in the present petition, which is directed against. You say at the outset, on the oral prayer of the senior counsel for the petitioner, the names of the petitioners, the name of the petitioner is altered as Chief Executive Officer, Mrs. Tata Power Distribution.
We have also prepared appeal, but however that matter was settled up. That was we have not.
So your name, you're asking the name of the company now.
Oh, sorry, sir. This is TPWDL. Tata Power Western Odisha Distribution Limited.
Western Orissa Distribution Limited.
Your lordship may say TPWDL.
The present petition is directed against an order dated December 2009, passed by the an order dated 29 January 2010, passed by the Grievance Redressal Forum, bracket GRF, whereby the complaint filed by the opposite party was accepted. And it was held that the opposite party complainant was entitled, one, for refund of excess amount of revised pro rata demand charges for the months of
March, April, May.
March to June 2009, and two, entitled to refund of rupees 4292,800, which was found to have been charged in excess towards single quotes excess overdrawal penalty, unquote, for the month of July 2009. Paragraph. As far as the first issue regarding pro rata demand charges, it is covered against the present petitioner by the order dated 21st April 2014, passed with this court. The petition civil 16836 of 2009, bracket Wesco versus Grievance Redressal Forum, bracket, and another bracket. Consequently, the court declines to interfere as far as the first issue is concerned. Paragraph. As regards the second issue, the court finds it has turned purely on facts. The complainant was able to show that it had been charged overdrawal penalty for both off-peak as well as peak hours, which is obviously impermissible, even according to the tariff order. Consequently, the differential amount has been asked to be refunded. The court is unable to find any error having been committed to the GRF in this regard. The petition is accordingly dismissed. Just ask them to leave. Ask someone to come. I think the same.
List item 43.
So for that, Lord single judge order is concerned, we have filed the appeal that WA number 228 of 2014.
That's all right. Yeah.
Only I bring to lordship notice.
All right.
My lord, item number 43.
On behalf of DP Dhalasamanta, his mother expired, my lord. 10 days. I pray, my lord.
What's the matter about, sir? Roughly 70 years old.
It is not audible, my lord. साउंड आସୁନି କିଛି
Trump is succeeded in reinstatement. And then when they refixed his pay, we'll pass the detailed order. Petition is dismissed. Right.
Weekly list item number 44.
So reflect along with me. Ratha is appearing with.
Item 44, in fact, here, the final order passed by the Debt Recovery Tribunal under the Debts Recovery Act was under challenge. In fact, the petitioners were not parties before the tribunal. Now, that's my beg to withdraw because by that time the writs were being entertained. And to avail other available remedy, it may be withdrawn.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to avail other appropriate remedies as may be available to the petitioner constant law. This post office withdrawn with liberty is paid for.
List item 45.
I am appearing for BC, my lord. May I please? My lord, for petitioner. Item number 45, my lord.
What is the item petition number, sir?
My lord, my senior name not reflected in the cause list, my lord.
What is your petition number, sir?
2295222010, my lord.
Tell us. What is the petition about?
My lord, permitted to withdraw with the liberty to file a fresh representation.
There's no representation now, sir. 2010 matter.
My lord.
But he is not for the petitioner, my lord. Probably he is appearing for the intervener petition.
Oh, I see. None appears for the petitioner, dismissed for non-possible. Right.
Weekly list item 46.
My lord, item 45 has become infructuous, my lord.
All right. Counsel, the petitioner states the petition has become infructuous.
Item 45, I am for the petitioner, my lord, on behalf of petitioner, my lord. Permitted to withdraw, I will approach the.
All right. Counsel, the petitioner seeks leave to withdraw this petition. All right.
Approach the opposite partner one with the better representation, my lord.
Weekly list item 46.
All right.
Item 46.
45, you say counsel, the petitioner seeks leave to withdraw the writ petition with liberty to file a fresh representation to opposite party number one. Dismiss is withdrawn, liberty is paid for.
46.
46, she says it is infructuous, it is disposed of.
Item 47.
The present petition was registered on the basis of a was based on the basis of was registered on the basis of a letter dated 28th April 2012 submitted by the Kidigam Parbat Prant Pradesh Raksha Samiti. However, the present petition was not listed even once in the last 10 years. The court is therefore not aware of the developments that have taken place in the meanwhile. The registry will inform the aforementioned organization that it can file a fresh petition accounting for the developments in the last 10 years in accordance with law. The petition is disposed.
Weekly list item 48.
48, no instruction, my lord.
Counsel, the petitioner states he has no instructions.
Weekly list item 49.
None appears to specific.
Not, I am appearing for the transport department.
All right.
Weekly list item 50.
None appears. None appears dismissal now.
Pastoral matter. Weekly list pastoral matter item number 7.
Lordship, in item number 7, I am appearing on behalf of Mr. Mukherjee. He really begs apologies that he's stuck in another matter and seeks a 1 day's adjournment.
No, it's not possible. So tell us what the matter is.
I'm really apologetic, my lords.
That's all right, sir. It's actually 3 o'clock. This should have been. It's after a Passover, so.
Lordship, one opportunity may be given to me.
No, sir, no,
I just pray for one opportunity.
No, we're not entertaining it, sir.
The Lordship will go through the counter affidavit, the
Yes.
scheme on the basis of which he is claiming his right.
Yes.
That scheme is no more in force.
Oh, I see. All right. Counsel for the respondent informs the court that the scheme under which the petitioner is seeking the prayers regarding settling the record of rights in respect to the plan
The fruits has also. This is, I am reading my counter affidavit page 4.
In view of the above statement, the petition is disposed of.
Weekly list pastoral matter item number 9.
None appears. Sorry. You found out, sir?
My lords, I talked to the present CA, competent authority. She has joined recently. I had told him to sort out the problems by Monday. Either you take or pay the compensation. Either or.
Especially the counsel for the opposite party states that a new officer, an officer has recently taken over as Special Land Acquisition Officer. And will attempt at sorting out the issue concerning the present petitioner. That is request list on 6th April. All right.
Supplementary.
My lord, may I be permitted to mention, my lord, item number 10 of this list, state is the petitioner. Actually, we could not get the file. It was dismissed for default.
We'll say as and when the file, you see the file.
No, I have already got the file. It is there with me. It is against the award of labor court. And the direction is for reinstatement and for back wages. So far as reinstatement is concerned, after 20 years, it is not. So Lordship can pass any order and just without dismissing it for default.
All right. See, dismiss on merits. All right. I'll dictate the order. All right.
Supplementary. Supplementary list fresh admission item number 1.
No instruction, my lord.
Counsel to the petitioner states he has no instructions. Disposed of.
Item 28, I have made a mention.
Tell us. Item 28. Yes.
28.
Tell us.
My lord. So, Lordship, in this case, the petitioners have challenged the order passed by the member board of revenue in Annexure 7.
wherein at the behest of the private opposite parties, the member board of revenue initiated the case.
Correct. This is also Sukinda, or this is Jagat Singhpur?
No, it is not. It is not Sukinda.
Oh, it's Jagat Singhpur.
It is Jagatsinghpur.
38B only, but
38B. 38B at the instance of private persons.
All right.
Miller, my submission before your lordship, the order of the Tahsildar was passed in Annexure 1 in 1979. So initiation of a proceeding in the year 1999, 20 years is bad, and it has been covered by the decision of the apex court and this honorable court. That is one. Second, the order of the Tahsildar being an administrative order, so it is
they should have gone to the civil court.
It is not amenable under section 38B. That your lordship will find that is also the decision of this honorable court in volume 100, page 2005, CLT 329. That once the Tahsildar passes an order recognizing the tenancy right under section 8.1, that is an administrative order and that is not amenable under section 38B. And also your lordship will the third limbs of my submission. And for more than 12 years, rent has been accepted. Therefore, under the Orissa Tenancy Act, section 22, a right, occupancy right has been accrued. So, uh, 2015, volume 14, SCC, page 497, and the SB Gurbakh Singh versus Union of India, that is 1976, 2 SCC 181. There, the lordship said that it should be in a reasonable period, and even 5 years delay, they say it is inordinate delay. So therefore, entertaining an application under section 38B after 20 years is bad. The third limbs of my submission, Miller, if your lordship see section 38B, Miller, 38B does not, in its scope and ambit, allow an application to be filed by private individuals. Miller. The lordship may kindly see in Annexure 7, at the behest of private individuals, 38B application was entertained and an order has been passed. Lordship may kindly see the language. The Board of Revenue may, on its own motion or on a report of the collector. Here both the things are absent. And it has been held by our Honorable High Court in also in volume 76, 1993 CLT 937. So I am giving the decision for your lordship's consideration.
You give us a note.
Miller?
Give us a note. Orders reserved.
Note. Miller. No. Yes.
Notes of submissions be filed within
Miller.
1 week. All right.
Obliged.
I am appearing for that same thing. This is also.
Supplemental list, fresh admission item number 2.
None appears. No.
I am appearing for the school and mass lordship.
Supplemental list, item number 3.
Item number 2 is infructuous, my lord.
Item number 3.
Item number 3, Your Lordship, we have filed an IA for amendment, miscase for amendment. Lordship, the amendment is formal in nature and requires deletion of the word Sabak in the paragraph 4.3 of the writ petition.
What's the matter about, madam?
Your Lordship, the matter is regarding the leasing out of forest land to private individuals and subsequent conversion of the forest land to various other natures of land like Sarad 2 and Patit. Your
Have you
Lordship,
made
these
those persons parties?
No, they have not.
Your Lordship, no,
They have not
no,
been
they have
made
not been made parties.
Then you'll have to file a fresh petition. The amendment is allowed.
Lordship,
The main petition, you say, counsel for the petitioners. You want to withdraw this to make a fresh petition, you can.
Your Lordship, I'll make a small prayer for consideration of Annexure 3.
No, even that representation, you have to name the individuals, please.
Your Lordship, in the representation, the individuals have been named.
Yeah, you may have to make a fresh representation now.
I'll make a fresh representation.
All right. Counsel the petitioner seeks to withdraw this petition with liberty to make a fresh representation with the authorities, and after following up on such representation, to seek appropriate remedies in accordance with disposed of his withdrawn with liberty is paid.
Supplementary list item number 4.
In this case, file not available. Any short adjournment tomorrow, day after tomorrow.
No. You say counsel the petitioner states that the file is not available. The petition is dismissed with liberty to the petitioner to revive it if the file is traced and if the cause of action survives.
Supplementary list item number 5.
In 5, I am for the opposite party.
None appears to
Distribution company. In both the matter, there are two matters connected.
Supplementary list item number 6.
May I please, Your Lordship? My Lord, this is an appeal challenging the order passed by the learned ITAT Millers Income Tax Appellate Tribunal, whereby, my lords, the tribunal confirmed the order passed by the Principal Commissioner of Income Tax. My lord, the facts is after the assessment order was passed, the Principal Commissioner of Income Tax took up the matter for modification under Section 263, my lords. And appeal was filed before the learned ITAT Millers, and ITAT dismissed the appeal and confirmed the order of the Principal Commissioner. Your Lordship may kindly turn to Annexure 5, which is at page number 30, which is the order passed by the learned ITAT. My lords may kindly see, my lords, page number 32, my lords, paragraph 7. Paragraph 7, my lords, is the sum and substance of the order on the basis of which the appeal of the assessee was dismissed, my lords. Paragraph 7 reads as, after considering the submission of both the sides and perusing the entire material available on record, we find that the principal CIT modified the assessment order invoking the provisions of Section 263 of the Act, observing that the AO has not made any proper inquiry, which should have been done by the AO of the amount received by the assessee under the head Commission, Exchange and Brokerage. On perusal of the assessment order, we observed that the AO nowhere has disputed or discussed the issue, nor any inquiry has been made.
For the department?
Yes. Question of framed.
Questions framed already. I don't think questions have been framed yet.
Yes, framed here. Page 10.
No, that is a question suggested, sir. Not yet framed.
Question framed. Substantial question of law.
Miller, substantial question of the law is, Miller, page number 9, paragraph 9, Miller.
I know, it has not yet been framed by this court, sir.
Yes, Miller. Yes, Miller.
A and C is enough?
No, Miller. So B, C, and D, E, G, Miller.
Not so many, sir.
My lord, all
this
this
revisionary power is enough.
My lord, otherwise G, Miller. G is most important, Miller. Non-speaking order has been passed, Miller. Non-speaking order and lack of inquiry, inadequate inquiry was not confirmed, Miller. No conclusion has been given. Therefore, B.
What is non-speaking order?
My lord, no proper reason was given, my lord.
That is not a non-speaking order, sir. That question does not arise then.
My lord,
I think question A is all right.
B, my lord, is inquiry conducted by the assessing officer.
No, I think A and F is enough.
A.
You say admit the following questions of law are framed for consideration. Take A and F from pages 9 and 10. Mr. Chimaka accepts notice of admission. List on 2nd August.
Much obliged.
Supplementary item 7.
Extra copy you can.
Yes.
May.
My lord, the petitioner is a hapless widow who has been appointed since 1998 on the basis of rehabilitation scheme after the death of his her husband, who died in harness. Thereafter, my lord, the 2009 granting order, she was supposed to be included, but she could not be included because of the fact that she has joined prior. She has not joined prior to 31st May 1998.
No reply has been filed.
My lord, no reply has been filed.
No,
Notice has not gone.
Notice has not.
All right.
Turn is not coming under that 2014 GIS.
Yes, I am submitting that thereafter verification has been made. And
All right. Notice, he accepts notice for opposite parties 1 and 2. Notice to opposite party number 3 is served by registered seat post returnable on the next date. Replies be filed within 8 weeks. Beyond the next date. 28th June.
Supplementary item 8.
May I please, my lord?
Yes.
My lord, in this case, the petitioner challenges the issuance of notice under section 148 of the Income Tax Act 1961 issued by
Yes, it's different from the March 7th matters.
No, yes, my lord. Here the approval is not given by the competent authority, and instead of CIT and
so this goes joint
yes.
CIT.
Yes, it has been the conclusion has been drawn.
Yeah, notice, he accepts notice. It is seen that the impugned notice issued under section 148 of Income Tax Act 1961 dated 29 June.
My lord, it is covered already by this course.
Yes. 29 June 2021 has been issued, not with the approval of the CIT, but only with the approval of the joint CIT. On this short ground, the impugned notice and all consequential proceedings are hereby quashed. The petition is disposed of.
Supplementary item 9.
My lord, petitioner challenging the proceeding passed by the opposite party number 4 without following the article of the association and bylaw of the board and also central government guidelines, while approving the proceeding of the board, not taking into consideration of the article of association bylaw. Firstly, the chairman and vice chairman attending the virtual mode during the time of introduction and proceeding should have approved by voting and signature of the board of members. That was not done, my lord.
We first ask just the state of Orissa. We will not issue notice to everybody.
My lord, I am opposite party number 20.
This Animal Welfare Board of India is a statutory body.
Yes, my lord. I am a representative member of the state Animal Welfare Board.
No, but why should you appear in person? I don't understand.
My lord, actually,
what have they got to do with the issue? You are for the petitioner.
My lord, I am for the petitioner.
Why have you
I am
implemented some 20
impleading
people?
he is a member of the board, my lord.
No, why have you implemented him?
My lord,
why have you implemented him, sir?
My lord, the proceeding was passed by all the members, my lord.
These
all
are
the members.
Association matters, disputed question of fact, and there is dispute between so far as the resolution passed in the association is concerned, as I find from the very reading of the writ petition. These are all amenable to suits. My responsibility is that he's
my lord.
Then
as per the
the
Society Registration Act,
any proceeding or resolution passed by majority, or the chairman
highly prejudiced because they earlier this honorable court directed to consider our case, my lord, because my lord, that is annexure page 10. Page 10, earlier a writ petition bearing WPC number 11974 of 2003 was filed. Before this board, my lord, there is State Animal Welfare Association. My lord, that association member was merged with newly constituted board, my lord. My lord, this honorable court directed while this board is this institution, this association was merged, they may be adjusted in the said board, my lord. But that is not taken into consideration, my lord. And the board's the proceeding was issued by the
Are they amenable to writ jurisdiction?
My lord, all the this issue, all the members are government employee, my lord. Most of the members are government, my lord, and that's why
the main prayer, substantive prayer in the writ petition, your lordship may find to set aside the annexure 5, the proceeding dated 22 of Animal Welfare Board, Orissa State Animal, and the yes. So Animal Welfare Board is opposite party number 20, I think.
No, my lord.
No, I am from government of representative of Animal Welfare Board of India.
Board of India. Yes.
My lord, in this case, my lord, state all 1, 2, 3, 4, all are the government machinery, my lord. All are member for the government machinery, my lord. And the board was constituted as per the direction of the Honorable Supreme Court, my lord.
Mr. Mohanty, can you just take instructions?
Yes,
my lord.
Mr. B.K. Mohanty, appearing on advance notice for opposite party number 1, states that he received instructions.
From opposite party number 4.
4, my lord.
Only 4.
From opposite party number 4. That is request list on 2nd May.
Supplementary item 10.
In this case, I challenge the ordinance dated 3-1.
Similar matter is pending in
31,
WPC
121.
4571 of 2020.
Yes, similar WPC number 4571 2022. Your lordship has been pleased to have
29th
issue
June.
notice.
Right.
And it is posted to June sometime.
Right.
During June.
List on.
There also the ordinance has been challenged.
On.
Here, my lord, the ordinance has been challenged. Your lordship may kindly have a glance to annexure 1 at page 17,
Yes.
wherein your lordship will see
Yes.
the ordinance itself, where the object and reasons
Yes.
of the ordinance has not been stated.
Yes.
Usually, the
So let them file a reply, sir. Let them file a reply.
We'll file reply.
Notice. He accepts notice. Reply we filed with it.
May I pray for stay?
Notice on stay also. List on 2nd June. No.
29th June.
Along with writ petition level?
4571 of 2022.
All right. 4571 of 2022.
Allowed to let the result be stayed, let the election continue.
Please.
No questions. No questions.
Subject to the result of the writ application.
No, not. These are election matters. This is not some appointment. Yes. All right.
Supplementary item number 12.
12.
Item number 12.
May I request kindly ignore the defect of page marking, then I'll proceed. Books of account has been audited and audit report has been filed, and it is a case of such 150A notice has been issued, and he has not produced any books of account. And kindly see the running page, statewide running page 34 of the tribunal's order.
Will issue notice. Who's for the other side?
First time it was issued.
All right. Notice returnable 28th July.
All four are same.
All right.
Question number A is sufficient, right? I.
No. Notice confined to question
number-
A in
Yes. Page running page 5.
para 7 bracket 1.
Right.
All right.
Bless.
12, 13, 14, 15.
All are same issues.
Supplementary item number 16.
Permit 16, 17 permit.
Council petition. Appellant seeks to withdraw the appeal. Dismissed as withdrawn. All right.
Supplementary item number 18.
That immigrant worker has already returned to his village.
Supplementary item 18.
He wants to give something.
Counter affidavit, of course, should have been filed much earlier. There has no filed. That immigrant worker, Rohita Vishwan, has already returned to his village.
Okay. In view of the affidavit dated 28th July 2016, filed by the collector, no further directions are called for. Petition is disposed of.
Supplementary list item 19.
None appears to slip in opposition.
Supplementary item number 20.
None appears to slip in opposition.
Supplementary list item number 21.
21 Millers, may I please Millers? Millers challenges the order dated 17/10/19 passed by the Honorable Claim Commission, wherein directed to provide employment who was minor on the cut-off date and grandson of the.
What's the reason for the delay, sir? You're filing it after 2 years.
Millers, due to the COVID, Millers.
No. What is COVID, please?
Millers,
17/10/2019, sir. It's all pre-COVID times.
Millers, same issue is pending before the Supreme Court. Judgment has been reserved, Millers. So that's a
Judgment has been
reserved by the Honorable Supreme Court.
all right. At the request of Mr. Devraj Monti, Learned Counsel, the MCL, list on 4th July. All right.
Supplementary list item 22.
I have filed the state petition with the sort prayer, my lords, for a direction to open
Defects are there, sir.
I'll remove it within 2 weeks.
Yeah. Council list after removal of defects.
Okay.
Supplementary item 23.
Dismissed or deferred matters, ma'am. Dismissed or deferred matters.
What is the main matter, sir? Tell us about the main matter.
In this case, my lord, the petitioner, my lords, was placed under off duty, that is suspension, by Annexure 1, my lords. So, lordship may kindly turn to page number 11, my lords. That is the order of
Main
suspension.
matter, that order is not there.
Suspension, my lords. Whereas an inquiry in respect of allegations of misconduct against Sri Haribandhu Raut, EDBPM, Podamarai BO, in account with Mahanga SO is under Kendrapada HO is pending, and whereas the further continuance of the said Haribandhu Raut is considered detrimental to the public interest. Now, therefore, the undersigned, in exercise of powers and so, hereby puts the said Sri Haribandhu Raut under off duty matters. That is via Annexure 1, dated 5/8/1992, my lords. And in this case, my lords, he has paid only substantial, that is called ex gratia compensation, which came into force with effect from 13/1/1997, my lords. In this case, my lords, he was in duty. Allegation is that he absconded, so he is not entitled to get the pension substantial allowance, my lords. Now, your lordship may kindly turn to the impugned order, my lords, at page 19, my lords. And tribunal has, my lords, boldly typed the relevant portions. Your Lordship may kindly turn to page 19. May I please, my Lords? Provided that a Sebak who has been absconding or remains absent unauthorizedly and is subsequently put off duty shall not be entitled to any compensation as ex gratia payment, my Lords. Below that, my Lords, that is important. Provided further that in the event of a Sebak being exonerated, he shall be paid full admissible allowance for the period of put of duty. In other cases, such allowance for put of duty can only be denied to a Sebak after affording him an opportunity and by giving cogent reasons, my Lords. In this case, my Lords, he was placed under off duty by order dated 5/8/1992, my Lords. Substance allowance came into force with effect from 13/1/1997, my Lords. And he was in duty, my Lords, on 5/8/1992. And in the entire departmental proceeding, he has participated, but substance allowance has not been paid. And he has approached the London Tribunal, and London Tribunal, basing on this, my Lords, page 19, has dismissed the original application on the ground that he was absconded. But even in case of absconded person, my Lords, he has to be given an opportunity of being heard. Without giving any opportunity of being heard, my Lords, substance allowance cannot be denied. But the London Tribunal has dismissed. Thereafter, I filed the review application mentioning the defects, mistakes in the order, my Lords. And the London Tribunal also dismissed the review application. Thereafter, I filed this repeat summary. And from 92 to 97, he is not entitled to get.
So you only ask for ex gratia.
Yes, ma'am.
It's only available to needy employee during his off-duty period.
Yes, madam.
But you refuse to receive the off-duty order, sir.
No, my lords. I asked them. Thereafter, my lords, it was I
No,
entirely, my lords,
something else.
I have for the my lords from the date of put of duty till my lords removal, I have entirely participated in the inquiry, my lords. I have appeared before the authorities whenever I was called, my lords. And the departmental proceeding, I was after giving an opportunity, I have been removed. Thereafter, I appeal before the authority and in the revisional order, my lords. The revisional authority also set aside the order of removal. Thereafter, my lords, again I faced proceeding, and again this for the second time he has been removed from service.
Right.
But put of duty allowance cannot be denied on the ground that I was absconded, my lords.
Yeah, why
even
not?
if that can be denied, but they have to give you an opportunity of being heard, my lords. Your lordship may kindly turn to page 19, my lords.
Yes.
Page 19, my lords.
You are not there, sir. How will they hear you? Unless you are present, they can't hear you.
Second paragraph.
Yes.
In the middle, my lords. It was decided to place the applicant under of put of duty in memo number so and so dated 5/8/1992, pending trial of the proceeding. But the applicant deliberately avoided to receive the put of duty memo and proceeded on leave by providing an unauthorized substitute with effect from 11/8/1992, my lords. 11/8/1992, my lords, he proceeded with giving one substitute, my lords. So up to 11/8/1992, my lords, he was very much available, my lords.
Yes.
And thereafter, my lords, also in the entire departmental proceeding, he has participated in the inquiry. It is not the case that he has not participated, my lords.
Right.
He has fully participated in the inquiry,
yes.
but no nowhere they have said that I have not participated in the inquiry.
Right.
In the entire proceeding, my lords, I have appeared. And thereafter, my lords, your lordship may kindly turn to the page 19, my lords. Third para, my lords.
Yes.
The relevant portion, the London Tribunal has relied. Provided that the Sebak who has been absconding or remains absent unauthorizedly and is subsequently put off duty shall not be entitled to any compensation as ex gratia payment. Thereafter, my lords, it is very important. Next para, the rule is very clear, my lords. Provided further that in the event of a sevak being exonerated, he shall be paid full admissible allowance for the period of put off duty. In other cases, such allowance for the put off duty can only be denied to a sevak after affording him an opportunity and by giving cogent reasons, my lords. Even in case of, my lords, denial of put off duty, they have to give a cogent reason and give an opportunity of being heard, my lords. That has not been done.
Right. The reason stated the application is allowed. In the main writ petition, having heard on counsel petitioner, there is no merit to the petition. I'll pass the detailed order. The writ petition is
Pardon to make item 20, my lord. Sorry, I was in another court, my lord. Item 20, my lord.
Yes.
Item 20, pardon.
Yes, please.
This matter related, my sole grievance is that I challenge the punishment order without availing the appellate forum. Your lordship may permitted to file an appeal
Or
before
counsel the
appropriate
petitioner
authority
seeks leave to
against the
withdraw this
punishment.
petition with liberty to first exhaust the appellate remedy available to him in accordance with law. This post office
Item
withdrawn with liberty is paid for.
Obliged.
Item 23, appearance of union noted.
Or
Item number 24.
Defect is there, may be removed within a week.
counsel will list after removal of defects.
Supplementary item 25.
My lord, this is PIL against Nestle company, my lord. That Nestle company prepared the kit cut.
Defects. Removal of list after removal of defects.
Supplementary item 26.
26, my lord. This is with regard to release of SCP, my lord, as your career progressive scheme, my lord. By virtue of this, my lord, I filed a representation before the author, before the Register Administration on 21/1/2019, my lord. Glance to page number 28, annexure 5, my lord. They have rejected by the annexure number 6 without any reasons, my lord. On 20th January 2020, my lord.
Why have you filed it so late, sir? Present petition is filed when?
My lord, I filed
more than 2 years later.
My lord, this was issued on 20th January 2020, my lord, but I received the same on 51/1/2021, my lord. At that time, I have retired, my lord. They have not communicated. I received from the district of Puri, my lord.
Anyway, you waited for 1 year to file this also.
As for the, my lord, Supreme Court decision, my lord.
You are special judicial magistrate.
Yes, my lord.
What is this assured career progression for a special judicial magistrate?
My lord, in the year, facts of the case is, my lord, in the year 81, I joined.
Are special judicial magistrates entitled to promotion?
No, that is not covered. Your lordship, I down annexure 4, page 21. Bottom, paragraph 4. For a career progressive scheme was at page number 26, my lord.
Yes.
On the same. With lord, the rules is as per rules, my lord, they have extended the benefit of all the benefit which have been granted to the magistrate, my lord. As per rules,
Magistrate also doesn't figure here. Sir. Unless this special judicial mission, you can't simply. Oh, for ACP, there has to be a specific order, sir. It's not automatic.
They have mentioned the civil judge junior division, civil judge senior division.
You say the resolution dated 2nd August 2010, issued by the Law Department, Government of India, Government of Orissa, does not in the petition represented special on the administrative side. The petition is accordingly dismissed.
Supplementary list item 27.
May I please, my lord? My lord, this is a matter of habeas corpus, my lord. The brother of the present petitioner, he was deported to Iraq, my lord.
Not sitting, is it? This is Yadash. Oh, he can't appear. All right.
My lord. He was deported to Iraq, my lord, from the capital of the Iraq, my lord, from Baghdad. He was sent to 120 kilometers, that is Babylon. And since last 24th, my lord, he was.
Mr. Pari, are you there? Mr. P.K. Pari.
Yes, my lord.
So you just inquire into this, just a notice.
Yes.
Mr. Pari accepts notice for opposite parties 1 and 2, as well as 8.
Yes, ma'am.
Item number 28.
Well, matter may be posted on 7th, my lord, on Monday.
Supplementary item 28.
None appears dismissed from opposition.
Supplementary item 29.
None appears dismissed from opposition.
Supplementary list item 30.
None appears dismissed from opposition.
Item number 30, I am present there, my lord.
All right.
My lord, item number 30. This matter relates to, my lord, Bhutan lands, my lord. Bhutan lands. My lord, am I audible, my lord?
Yes, yes.
My lord, the Bhutan lands.
So why don't you go to the Lokayukt, sir?
Local?
Why don't you go to the Lokayukt? You are claiming land scam, correct?
My lord, my lord.
Why didn't you go before the Lokayukt?
Lokayukt, my lord, because judicial inquiry I prayed for, my lord, because the
Lokayukt is meant for only things like this, sir. The Lokayukt has been set up for this. You say, given the subject matter of the present petition, the petitioners are permitted to go before the Lokayukt if the cause of action still survives. The petition is disposed of.
Obliged, my lord.
Supplementary item 31. Supplementary list item number 31.
Permitted to withdraw, my lord.
Cause the petitioner seeks leave to withdraw this petition.
Supplementary item 32.
None appears dismissed in opposition.
Supplementary item 33.
May I
No
please,
instructions, man. All right.
this is a matter for. May I please, item 32, my lord. This is a matter for of PIL. Yes, my lord. Am I audible?
Yes.
This is a matter of PIL, and the petitioner is the regular plot donor. He has filed the PIL petition for an impartial inquiry to direct the blood bank, the OP number 4 and 5. The fact of the case is like this: the petitioner is the blood donor, and like the petitioner, most of the blood donor donate the blood as and get the certificate. But these blood which are collected by the blood bank and the Red Cross, they are collecting the blood from us and you selling the outside.
What is the proof of all that? Don't base it only on a news report. Do you have any concrete material?
Yes, my
Where?
lord. That is a news
News
report.
report is not
under
evidence,
Annex
please.
2. My lord, this is my lord. I may be permitted. This is a PIL for a direct. My lord. Hello? Am I audible?
Yes, yes.
My lord, for OP number 4 and 5 for an impartial inquiry regarding the exploitation to the innocent blood donor, which amount to.
You have to give concrete examples, madam, not just a news report.
My lord, this has published in the newspaper.
It is not enough for us, madam. Publishing a newspaper is not enough. You have to give us some concrete examples.
My lord, so I may be permitted to file the affidavit giving some materials regarding this exploitation.
So madam, you file a fresh petition if you find those affidavits.
Withdraw this, file a better petition.
My lord.
Particular.
Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file a better petition with affidavits of actually affected persons. This post of is withdrawn with liberty. No, 32. 33, he said he has no instructions.
Well, 30.
Petition is rendered infructuous, disposed of as such.
Supplementary list item number 38.
Your Lordship, if I may be, may I please, Your Lordship, this is a matter relating to illegal appointment of law officers of Board of Revenue.
The counter affidavit that is not in the record. That is the noting.
All right. The counter affidavit stated to have been filed by the opposite party be brought on record, adjourned for the next date. This on 5th July.
In 9 that is. Supplementary item number 39.
Mr. Padi.
This is section 22/3/2022. This month only. By 22nd, the P will be joined in Cuttack. This paragraph 4 of my affidavit was reflected. May I audible, my lord? (2022) and it was fixed the date that he will join by 22nd March 2022.
Oh.
So this
All right.
month he will join.
Mr. P.K. Padi refers to the para 4 of his affidavit. bracket, which should be brought on record with the registry bracket, according to which the person offered the appointment to the post of DRT Cuttack has been given time till 20th March 2022 to join. At his request list on 22nd March.
Second March. Supplement.
He is given time till 22nd or 20th?
22nd March 2022, man.
Oh, till 22nd March at his request list on 28th March. All right.
Oblige, man.
Supplementary for hearing item 40.
Before your lordship takes up the hearing matter, item number 7 on the weekly list, Manoj. I miscalculated the time. I wanted to reach your lordship.
But you tell us now also, no?
Yes.
May I interrupt, my lord?
Yes.
The last occasion, my lord directed for personal appearance of the concerned officer. It can
All
be
right. The
dispensed with
personal appearance of the concerned officer is dispensed with. Right.
virtual mode. Yes, Mr. Gochayati appearing with me, my lord.
All right. All right.
Oblige, ma'am.
May I? This is a repetition.
Yes.
Where Malaj, I prayed for
ROR. You wanted some ROR for cashew plantation.
Yes, Malaj.
So he said the scheme itself is not there now.
No, under the scheme, these rights have crystallized. They were settled. Lands were settled with these landless persons, and they were given these tracts of land on which they were to cultivate and earn their livelihood. So, Malaj, under the scheme, these rights have already vested. That is the scheme. Malaj, may I take your lordships to the scheme itself?
Yes.
That is, your lordships will get that at page annexure 2 at page 50.
Yes.
Your lordship sees the column. The objective of this program is to ensure an annual income of not less than 1,500 to each of the identified beneficiaries by providing some steady income, generating assets depending on their aptitude, background, level, skill, covering various kinds of schemes like 1. Development of cultivable wasteland for annual cropping. 2. Plantation of cashew, coconuts, coffee, etc. We are not concerned with the others. I will not bother your lordships. Now over the page 51. In case of assets like cultivable land, ownership rights can be given to the beneficiaries as far as possible at the beginning of the scheme. In case of plantation land, however, either ownership rights over the land or only dafat right over the plantation may be given depending on the location of lands. Thereafter, Agriculture and Cooperation Department in subsequent letter issued suitable instructions to distribute amongst ERRP beneficiaries through the concerned BDO the existing cashew plantations having area of less than 40 hectares, which was not transferred to Cashew Development Corporation. This is what we are concerned with. Now, thereafter, your lordships at page 52, what are the kinds of lands which can be settled? All types of government land other than reserve forest can be identified for the scheme, provided they have not been selected for any other purpose of economic development. In other words, land, even though not recorded in Abad Yogya Anabadi Khata, can be selected for the purpose. B, for the plantation program, lands not recorded in the Abad Yogya Anabadi Khata can be selected since they will ensure vegetative cover. Full royalty rights will not be given in respect of the lands mentioned in B above. Instead, only dafati rights will be conferred on the beneficiaries. Thereafter, in D, last sentence, royalty rights will be conferred on the beneficiaries in respect of these lands in due course. This was this. Thereafter, para 2, in the first para, last 3 lines. This alienation will be temporary for the purpose of developing the land till its settlement with eligible beneficiaries or till conferment of dafati rights on them. Dafati rights will be conferred on 2 acres each on eligible beneficiaries in respect of cashew plantations when they bear fruit and yield a reasonable income by the Tahsildar on receipt of details of beneficiaries from the BDO. Thereafter, page 53, the following procedure shall be followed in the matter of conferring. D is important. The benefits conferred under these orders are heritable. The plantations are also transferable only in favor of similar beneficiaries and not outsiders with approval of the Tehsildar. I is again important. On conferment of Dafayati rights, an annual fee of ₹1 per tree will be levied on each beneficiary by the Tehsildar. Then page 54. So long as the plantation remains the property of the beneficiary, government may, after duly notifying him, use the land for any public purpose which is not inconsistent with the scheme, which does not create any difficulty for the beneficiary in enjoying full benefits from the plantation. So long as the above and other terms and conditions as may be determined by the Agriculture and Cooperation Departments for facilitating or expediting implementation of the scheme are satisfied, the plantation will remain the property of the beneficiary. Thereafter, the next paragraph, the plantation may be resumed by the government at any time if the land on which it is raised or plantation itself is required for public purpose. In such an event, compensation for the plantation will be payable by the government in accordance with the principles laid down in the Land Acquisition Act. So, this, my lords, is the scheme. Under the scheme, along with 20 other persons, these 6 petitioners were the beneficiaries. That is borne out from Annexure 2. Your Lordship may take page 8 of the writ petition. No, sorry, my Lord, page. Now, the petitioner's name figure in the rent receipts, page 12, 13, these are allotment sheets, Annexure 2, page 9. So page 9, your Lordships will find at the bottom, starting from the bottom, there are 26 petitioners, 26 persons, and the petitioners figure as 1, 5, 6, 7, 8, and 10.
Yes.
Now, my lords, your Lordship, let's see the counter affidavit of the government. First, your Lordship will take page 48.
Yes.
48, my lord, this is part of the counter affidavit filed by the Soil Department. Office of Land. According to the claim, the development cost of plantation of the land in respect of each family is limited to ₹5,000. Thereafter, at the time of plantation, these family members of the beneficiaries were engaged for development of the land and plantation in that land and its nourishing till it produces food. Entire cost is borne by the state government in Agriculture Department in ERRP scheme. Thereafter, your Lordship may next take page 42.
No. Just complete this, sir.
Therefore, the allegation petitions, they have engaged laborers during initial plantation and maintenance of cashew, etc., are not free. Are not free of cost. Rather, they are paid for the same only because they have planted and nourished the plant. They cannot claim Sthitiban status over the state land.
It may not be out of place to mention.
It may not be out of place to mention here.
The scheme was introduced for 5 years as per the guidelines communicated to all collectors in Agriculture and Cooperation Department. So and so, due to efflux of time, the petitioner's right to enjoy the fruit has also ceased. True copy of the guidelines for implementation of the program of economic rehabilitation of rural poor, communicated in letter dated so and so, is annexed here with annexure B/2. So, well, it's 5 years, even assuming that it was 5 years, was for the implementation of the scheme, not for taking out the benefits of the scheme. Because in 3 years' time, the fruits will start growing. Then I will be left with only 2 years. So this 5 years is for the implementation of the scheme to reach out to the maximum number of beneficiaries who are landless, and to rehabilitate so that they can be a part of the mainstream.
Where do you get this ROR? Your prayer is for an ROR to be.
I'm coming to that, my lords. That's from the government's counter, I will show it, sir. Next, your lordship may take page 42. This is the Soil Conservation Department's, no, this is Tehsildar. Tehsildar's affidavit. Page 42.
The short facts of the case are.
Last 5 lines. Finally, when the land will be fit to generate funds, the same will be given to the selected 10 families either on ownership rights or in propriety rights. Means ownership will be lie in the government, but the person in possession will have the right on the products of the land. Thereafter, next your lordship may take page 37.
Going back.
These are actually the opposite parties have filed. These opposite parties, in the order that they have filed the counter affidavit, it has been. But page 37, about paragraph 5 lines into that paragraph, the sentence beginning the scheme envisages that the fruit-bearing trees would be planted on waste, barren government land, and the beneficiaries would be called upon to tend the plant, and ultimately when the tree plants would become fruit-bearing and would start giving income, the same would be transferred to the beneficiaries so selected and would continue to possess the land trees as owners thereof and carve out their living from the usufructs coming from these trees plants. The beneficiaries would be granted ownership status on the payment of annual fees, land sales, etc. during their lifetime and by their legal heirs also. This is the government's counter. Thereafter, my lords, next page.
No, this is by the soil conservation officer.
Yes, by this another wing of the state government only.
He may not be aware of what the position is.
Tehsildar's counter affidavit is also there.
My lords, on one side is the state. On the other side, these are people who were landlords. Yes, very much there. In fact, I've stated on affidavit as back as in 2019, I think, that every, I'll just read out that portion, my lords.
How do we know these people are still continuing there?
Sorry, my lord?
How do we know they're still continuing there, these 6 people?
My lord, they keep coming to me every day, the cases.
No, one is 71 years. This was filed in 2002.
Their sons are coming, my lord.
Then have you substituted?
So one who can only enjoy the issue from
the permanent tenancy right cannot be conferred under the scheme. They are only the dafadari right.
The fruits only.
They will only enjoy the fruits.
Sorry, Balaj,
right, that right under that quota you are speaking.
Dafadari
right. It's a limited right to enjoy the issue from.
Yes. Yes,
only he can enjoy the fruits.
Yes. I am only concerned with that. I am not saying that give me a record of rights in respect of the land. Give me only a record of rights to enjoy the product.
They have issued similar quotas in respect of others.
That is the reason I am before your lordship, my lords.
No.
Record of right means not with a particular status or confining to enjoying the usufructs of the land.
Sir, come to para 5 of page 43. This has already been granted. Just come to page 5.
Page 5.
Para 5, page 43.
Yes, my lord.
The facts, this is the Tahsildar's affidavit.
Yes, my lord. Conferred with the
They are saying you are asking for settlement of the land on ownership basis. That's what they are denying.
My lords,
they have no problems giving you this dafayati right.
See, my lords, paragraph 8 of my rejoinder. This is the rejoinder filed by me on 14/8/2019. 14/8/2019, I had filed a rejoinder. Kindly see para 8 thereof. Your lordships got that one?
Yes.
That on the contrary, after the super cyclone, they took a stand in one of their affidavits that the super cyclone, the entire plantation was wasted. That on the contrary, after the super cyclone in 1999, the Tahsildar has been conducting inquiries from time to time, and last such inquiry was conducted couple of months back, wherein the number of trees standing on the land of each of the beneficiaries were counted and indexed. The government is purposefully holding back the said report, which would establish that the cashew plantation is still in existence. This is an affidavit dated 14/8/2019. Now, my lords, their understanding, what is their understanding of the is borne out from their counter affidavit, which I will just read out to your lordship. The Tahsildar had filed an affidavit.
No, but are you sure these petitioners are all still around?
One of them is dead. I filed for substitution. The others are there. Petitioner number 3 is dead. Substitution application is IA number 5331 of 2021.
(2010). No, but you're not coming to the main issue, sir. What are you claiming? If you're claiming dafayati rights, they will say that's already been conferred.
My lords, your lordship only records that and disposes of the writ petition. I have nothing more to say.
Right.
That I have a dafayati right over the land, and I'm not an encroacher.
But
right was conferred on them for 5 years.
Right or bhalo bhogo that
not that indefinite period they will enjoy the right of
the food. But in your prayer, what you have stated is that right to possess the land. Plantation in their possession with petitioner by issuing record of right. You have exceeded.
Your lordship may see my predicament. Your lordship may see.
Prayer, what you have stated.
Your lordship may kindly see the affidavit filed by opposite party number 4. Paragraph 5, Manoj. That at the outset, it is submitted that from the aim, objective, and principles of implementation of the ERRP scheme, it reveals the beneficiaries will not have any right over the land, and the land will be used only for implementation of the scheme and not otherwise. In the present case at hand, 52 acres of land were identified in the village so-and-so. The Soil Conservation Department has undertaken the cashew plantation on those lands. From the allotment sheet annexed by the petitioner as Annexure 2, it reveals that Kisam of 52 acres is Gramya Jungle and a Rakhit Khata and not wasteland. Petitioners were conferred with dafayati rights but not ownership rights. The then Tahsildar of Balikuda Tahsil is not a privy to the said allotment of land annexed as Annexure 2, as the land is objectionable one, And then Tehsildar had initiated encroachment proceedings against the beneficiaries for eviction under the OPL Act. After giving opportunity of hearing to the parties, the Tehsildar passed an order of eviction in all the encroachment cases and has collected fine and penalty from the encroachers. So I've been treated as an encroacher. This is the reason why I was before your lordship. Even though a right was being given on one hand, on the other hand, I was being treated as an encroacher with OPL proceedings under the Prevention of Land Encroachment Act being foisted against me. So I just want a protection that my only right to the plants be protected. I'm not asking for anything more, my lords.
My lord, what my learned friend is submitting, that is contrary to the prayer made by him in the writ petition.
Anyway, now he says he's happy if he...
But so far as that aspect is concerned, I would like to draw your lordship's attention to the guideline of the government that is annexed to the Tehsildar's counter affidavit. That guideline, it is not a permanent right. It is, the scheme was valid for 5 years. They were given 2 acres of land each for plantation and enjoying the fruits. And that scheme is already abolished. My lord?
No right over the land.
No right over it. It's not a permanent right. That is my only submission. That is why
he's saying, consistently continue. Why should you oust them?
No. After completion of 5 years and after abolition of the scheme.
5 years scheme was in 1980. 85 scheme was over.
Yes, my lord.
So now for over 34 years they continue cultivating.
No. The encroachment case was initiated, your lordship may kindly
much later, 2019.
95. Yes, 95, 96.
So and still in 2019 in your affidavit.
No, the affidavit is, but encroachment case numbers I have given in para 5, which my learned friend has read.
No, encroachment case numbers even extend up to 2001, sir.
Yes, 2000, 2001 to 95.
Anyway, this affidavit is filed on 15th March 2019. Right?
But the 2002 status quo order was passed. That is the reason for which we could not proceed with the encroachment case.
So why don't you formulate a policy now? If they have continuously cultivated,
they have already entered the land for more than
20 years. They've been cultivating, sir.
You have created the problem, so you have to find out the solution by.
Soon after the abolition of the scheme, we initiated in encroachment cases against them, and thereafter in 2003 status quo order was passed, and we are restrained from evicting them from the land.
Well, if the government were to make a representation that the rights that have been conferred to you are heritable and transferable, is it open for them to now say that it was only for a limited period and
that is the guideline?
Kindly understand, kindly appreciate, my lords. These were rustic persons who were given such understanding and given a right, my lords, over that is all they had in the world. They were landless persons.
So you better find out if petition number 1 is still around. He's 91 or 92 now.
His son had come
5331. You say
his
for
son
the
had
reason
come to me
stated.
yesterday morning, my lords.
Son has come. We're talking about substituting him, sir. 5331 of 2021 for the reason stated there.
Even in 2021, in March 21, I had filed one substitution application.
No, that we're allowing now. That's for petition 3. We're now talking of petition number 1.
I'll find out. I'll find that out. I'll find it.
This application is allowed. And then the main writ petition, you say this court has heard the submissions of Mr. Mukherjee, learned senior counsel of the petitioner, and Mr. D.K. Manti, learned additional government advocate. Paragraph, the issue concerns 6 petitioners who claim to have been cultivating cashew plantation pursuant to a rehabilitation scheme of the government of Orissa.
Government of India.
Government of
Implemented
India.
by the state law.
Implemented by the government of Orissa for over 30 years now.
1980, it is about 40 years, I think.
86, sir. 86.
86.
Paragraph. At one stage, the Tehsildar Balikuda, District Jagat Singhpur, had filed an affidavit dated 15 September 2003
2019.
19.
No, 1 minute.
Was that,
Para 5, he had
contrary,
stated,
yes,
where in para 5, he had stated as under, reproduce the whole of para 5 from page 43. Paragraph. Subsequently, an affidavit was filed by the Tahsildar, by the Tahsildar Baliguda on 15th March 2019, where this time in para 5, it was stated that the petitioners were conferred with dafayati right, but not ownership right, and that with the land being an single quotes objectionable one, encroachment proceedings were initiated against the present petitioners, and fine and penalty had been collected from them. Paragraph. An interim order was passed in the present petition way back on 24th March 2003, directing status quo to be maintained. As a result, for nearly 35 years now, the petitioners have been on the land, cultivating it, and enjoying the fruits of such cultivation. In the considered view of the court, the state government should seriously consider whether a fresh policy needs to be formulated, fresh policy or scheme should be formulated, recognizing the position of the petitioners over the land in question. A direction is issued to the Department of Agriculture, Secretary, Department of Agriculture, to place on record the present stand of the state of Orissa in this regard, in the form of an affidavit to be filed at least 1 week prior to the next date. Interim orders to continue list on
May it please your lordship. If question number 2 in this case, my lord, report for a substantial question of law. Cash credit under the provision of section 68 of the IT Act, when the appellant had no books of account as required under the provisions of the Act. Now, to substantiate the matter, the daughter was, in fact, the assessee. Daughter was married to in the year 2025 to 2021. Thereafter, she left 2001. Thereafter, shifted to USA August 2004, and she married to an engineer or mechanical expert. So, in this category, there was substantial deposits, cash withdrawal by her from bank account, 10,75,000. Others gift on 2/7/2010 from her taxpayer money. Other is salary holder, 6,25,000. Marriage gift she has received.
Actually, come to page 55, sir.
Yes.
See, your daughter filed an affidavit.
Yes, my lord.
That affidavit is not believed by the AO.
My lord, before the CIT appeal, she has filed affidavit.
When actually 41 lakhs was received for the purchase of our property at Bhubaneswar from his married daughter. This is your explanation given. So for that, the daughter gave an affidavit saying,
Yes.
I gave 41 lakhs to my father.
Total 41 lakhs she had accumulated.
No. So she gave an affidavit saying, I gave 41 lakhs to my father from 3 sources.
Yes, to purchase the land.
Correct. Now this explanation, page 55, now read on. The AO, why he disbelieved it. AO disbelieved it, CITA disbelieved it.
Yes, my lord.
CITA also has disbelieved it. So concurrent findings against you.
The cash gift. the assessee, even though said that he has received entire amount of rupees 41 lakh from his married daughter who resides in USA, and the money has been deposited by the assessee during the year, but in the cash withdrawal from the bank on various dates have been explained by Srimati Gayatri. This is the daughter from whom the assessee received the money related to the period 8/8/2008 to 7/6/2010. The cash gifts are related to the period 2007 to 2010. Marriage gifts are related to the period when marriage had taken. Also, the time of marriage.
Keep this cash with her in the US, sir. Doesn't make
My
any
lord,
sense.
that they have maintained the bank account and they have this is
Sir,
the
all
annexure 1, my lord.
in the Indian currency, she's withdrawing from the bank here and keeping the Indian currency there.
That is in Indian bank 17, annexure 1. She has time to time, she has with it.
It's all
ICICI
unbelievable.
bank.
Completely unbelievable.
But-
Totally unbelievable.
No, my lords, then how, even if it's my humble submission, when regularly she is drawing money.
How can she, sir? First of all, she's living in the US.
Not
She's married and gone to the US. Let's face the facts. Very unlikely that all lakhs and lakhs of rupees she's keeping with herself.
My lord, 2001
in the US.
She got married, and 2004 she left for America, USA. Then
Even this
the
marriage
accounts are
gift kept aside for future needs, 24 lakhs. What does that even mean?
24 lakh. That
The most improbable kind of explanation.
That description also has been given.
Nobody's giving marriage gifts of 24 lakhs.
My lord, that is page 9 that she has given the description of the gold ornaments, etc. What she has received. That father-in-law. was
Nobody
kept
converts that into cash, sir. That remains only as golden ornaments.
So in that case, my lord, if you are
They
not
are asking you simply, where's the source of your cash? 41 lakhs, you've got cash.
my lord, if it is
So
not
you gave an unbelievable explanation that my daughter gave me the 41 lakhs.
no, doctor has received from various sources.
No.
My lord, from the beginning for the ITO,
Yes.
that explanation she had filed.
All
I
right.
have a glance to 43 page
Right.
by the AO to whom that explanation was given.
Yes.
During the course of assessment proceedings,
Right.
the heir of the assessee was asked to furnish documents and reasons regarding the source of cash deposits amounting rupees 41 lakh in savings bank account. In reply, the heir of the assessee produced documents, sources of income regarding the cash deposits. Explanation from the beginning. In case it is not believable, my lord. Given money and builder has also acknowledged the money, not at a time huge amount was given. So my humble submission, this cannot be taken as section 68, my lord.
Mhm.
In this case, our the Honorable Apex Court said in the case of that is CIT versus Orissa Corporation, that they should have issued summons to know, because last year the revenue did not examine the source of income they said alleged creditors to find out whether they were credit worthy or such who could have advanced the alleged loan. There is no effort made to pursue the so-called alleged creditors. Thereafter also Bombay High Court, Honorable Bombay High Court said, this cannot come under 68. They have taken the entire amount 68. So nothing has, they are known persons, they could have been examined and they should have even called for the, where the person was giving, everything was there, even builders. He has not issued at a time, my lord. So those who have been non-residents or they are purchasing crores and property, you know. So that is believable to some extent. So my humble submission,
yes,
nobody has prevented the department.
Yes.
Nobody has prevented the department to carry on inquiry and to pursue, ask the presence of the persons and to call for their explanations and their credit worthiness.
Correct.
Only one point. Page 48, para 4.
Yes.
I have considered the matter carefully. It is found that 41 lakhs case was deposited so and so, and there is debit of 41 lakhs in the said account in the narration of transfer to LIC mutual fund, which means that rupees 41 lakhs deposited by the appellant in case has been invested in LIC mutual fund.
Amount has to pay because it could not payment could not be neutralized, and that's why it has kept for the purpose subsequent pay. So nobody has denied, nobody prevented department, my lord.
Right.
Enough equipment they have got, instrument they have got, 131 could have been issued, and they could have been produced, taken the task, correct, detailed inquiry could have been made.
All right. Not inclined, so we pass the detailed order. Appeal dismissed. All right. Right.